Mr. Speaker, at this time, Representative Boyer moves to call out of its order House Bill 800 on today's notice given list.
Without objection.
House Bill 800 by Representative Boyer provides relative to the calling of a limited constitutional convention for the purpose of framing a new constitution, provides for fixing the time, place of the convention, provides for delegates, organization, staff to require that the Constitution be, as adopted, be submitted to qualified electors, provide for the application of specified laws, disbursement of funds, place limitations on the convention to fix the date of the new Constitution if approved by the electorate. And as a reminder, there were previously adopted amendments to this bill.
Rep. Boyer on your bill.
Thank you, Mr. Speaker. Thank you, members. It's my pleasure to stand before you today to present House Bill 800, which will call this legislature and delegates appointed by the governor into a constitutional convention. This bill has been thoroughly vetted over the last month in our House and Governmental Affairs Committee. We have taken substantial public input as we've gone through this process, and will continue to listen to the views of the people of our great state of Louisiana and to you, the legislature. Thank you. As such, we've highlighted items that we would like to be protected in the Constitution and added them to this bill along the way. Articles 2 through 4 have been protected, and that's the balance of power and the establishment of our government. Article 1 is the Declaration of Rights, which provides that right to dignity, right to property, right to vote, freedom of expression, right to religion, protection of our Second Amendment rights, right to fair trial, amongst other things. Last week on this floor, in Article 7, we heard the voice of the people, and we added a protection of the homestead exemption that everyone continues to have liberty with. We also, in Article 8, added the protection for our K through 12 education, where we protected K through 12 education with regards to the MFP. These are examples of us listening to the people of the state of Louisiana and the input that they have provided. Why do we need this convention? Why do we need it now? Well, as you know, we do have an election this fall. It's a statewide election. In 2025, we do not have that liberty. If we want as much public input as we can get, this fall is an important time period. It also allows us to address the over $500 million shortfall that's projected to have next year. We have amended the existing Constitution over 200 times. And those amendments have restricted our ability as legislators to legislate. It's preventing us from having the flexibility to address those items when we need and are called upon to do so. During budget shortfall times, what falls on the chopping block is higher education and health care. Yes, that, if you remember from 2016, that was your granny in the nursing home, and college football, and other important academic issues that relates to universities. We will continue to listen to the people of Louisiana and continue to listen to you all as we go through. To further that element, I have an amendment that I would like to add as it relates to the date of the convention.
Madam Clerk.
Mr. Speaker and members, at this time, Representative Boyer offers up amendment set 4021.
Rep. Boyer, your amendment.
Thank you, Mr. Speaker. So remember, this has been something that we heard in committee. This is something that has been articulated by you all, and it's the timing of the convention and our ability to conduct work as a legislature while we're considering the convention. So I'll explain the amendment and take any questions on it, but essentially we would do this. We would allow ourselves to be called in no earlier than June 3rd. Let me make sure I got these dates right, just because I'm getting this amendment now. Excuse me, May 3rd. May 30th. Thank you. On May 30th, thank you, which is a couple of days before the sine die event, a sine die for this body. If we end up sine dieing later, we can convene the convention at that time. We would essentially go into a convention, establish committees to be able to vet different articles. That committee would be able to hear the articles during the summertime, during June and July, and would report to the full convention, which would have a full assembly no earlier than August the 1st, and ending no later than August the 15th. So to paint that picture, we could gavel in as soon as we sine die here, create the convention, adopt rules, come into the convention, establish a committee, and that committee would have the authority to have public hearing and public input throughout the summer as that committee deems. It would allow all of you to participate if you would wish, but it would also have the committee being able to do some of that heavy lifting during the summer, stretching out the time that we could take public input. And I think this is something that has been popular when we've been vetting it with you all and with members of the public. So we would not come into the convention as originally scheduled on May 20th. Instead, we would have committees meeting during the summer and would have the full assembly at the beginning of August. At this time, I'd ask for your adoption of this amendment.
Rep. Hughes for a question on the amendment.
Thank you, Mr. Speaker. Thank you, Chairman Boyer. I want to ask about the process of the committee. Will those meetings take place here at the Capitol, or will they mirror the redistricting meetings where the show goes on the road? So are we going to the people, or will the people be forced to come to us?
This amendment does not address that. It could go on the road. It could be held here at the Capitol. So this amendment does not address where the meetings are taking place. You could have a combination of both.
Okay. And the committees would go article by article, you said?
That would be the intent, yes.
Okay. And then the committee would make a recommendation to the full convention?
Where we would, yes, and then where we would then deliberate what the committee found and make a decision on whether those items would stay in the Constitution or move to statute.
Okay. And will this be one super committee, or will it be multiple committees?
It can be either. I mean, the way we have it drafted is to allow either. Depending on the input that you all provide and how many of you would like to be on the committee or committees, we could have multiple committees. If it narrows down to where we have a dozen or so people that really want to roll up their sleeves and get to work vetting it, it could be a super committee.
Okay. Thank you, Chairman. Thank you, Mr. Speaker.
Thank you.
Any objections to the adoption of the amendment? Hearing no objections, the amendment is adopted. Back on the bill. Rep. Hughes for a question on the bill.
Thank you, Mr. Speaker. First of all, Chairman Boyer, let me thank you. Today in the prayer, we heard prayer for civility, and you have set the tone with civility throughout this process, and I just want to publicly thank you for that, and thank you for your leadership. Obviously, I've been getting a lot of questions back home regarding the mechanics of the convention. And so I guess now I'll start on page 4, line 4, subsection B, where it provides for limitations regarding the convention. I've talked to a lot of lawyers that specialize in constitutional law. I've also spoken to some folks that were actually a part of the 1973 convention. And they have told me that the enabling legislation could be ignored. In fact, they said that enabling legislation was ignored in the 1973 convention. So, Chairman Boyer, my question on behalf of my constituents is, could you say confidently, unequivocally, confidently, without a shadow of a doubt, that we will be bounded by the enabling legislation should we go into a constitutional convention?
Yes, I do believe so. And I think to even further that, so the question that you have is questions that we've all received. I've received them as well. One of the first items we can do in the convention, once we convene, is to adopt this bill and say, hey, we're going to stay in the confines of this bill. And I think that shows the good faith of this body. This is the good faith of me as the author here. And I think, that we're going to be able to do that. And I have the commitment of the governor, I have the commitment of the president of the Senate and the Speaker of the House. You have all of our commitments that we're going to stay in the confines of this bill. So if that is legally challenged, you do have our commitment that we're going to stay within the confines of this bill.
Okay. And speaking of legal challenges, I was trying to find in the proposed enabling legislation, but did I read correctly that if a judge is a delegate to the convention, they would not be required to recuse themselves? Is that accurate or inaccurate?
That's accurate.
Why would we not want a judge who is an actual delegate, that is part of deliberations, should a challenge to the constitutionality or anything regarding the convention reach a judge that was part of these deliberations? Is that not a direct conflict of interest?
No, I don't think it's a conflict of interest. I think, number one, I think they would be in a better position because they would have sat through some of the deliberations, have heard different arguments. That's not necessarily saying that this judge would have voted for or against a new constitution, but I think they should be able to, and as a judge, you ought to be able to impartially separate yourself and to be able to make a fair judgment on the constitutionality of the Constitution.
Okay. Correct me if I'm wrong, Chairman. It takes a 2/3 vote of this House and the Senate to go into a constitutional convention. Is that accurate?
Yes, sir. This bill requires a 2/3 vote.
But once you're in a constitutional convention, my reading of the enabling legislation states that it would only take a majority vote to take actions on items. So if it takes a 2/3 vote to go into the convention, why shouldn't it take a 2/3 vote of the delegates to adopt a provision?
The way the bill is drafted, it requires a majority vote of each one of the delegate groups. So it takes a majority vote of the House, of the Senate, and of the governor's appointees.
Right, so it would take today it takes 2/3 vote for this enabling legislation to pass, but once we're in a convention, it's my understanding from the reading it would only take 53 votes of the House, 20 votes of the Senate, and then we have 27 gubernatorial appointees. So it would only take a majority there. Again, why wouldn't we want a supermajority that would mirror the fact that it takes 2/3 to go into it?
The thought that we had these three units within it was protection that we felt that would be there should any of our bodies object to one of the provisions. And so we thought that was a high enough threshold to have to go through to get all three to agree would be a big deal.
Okay. And let me just ask about the mechanics once we're actually in the convention. So, because forgive me, I don't think any of us were part of the 1973 convention. I think Representative Thompson was probably has the most historic knowledge. But can any delegate make any type of motion from the floor, or how will that work?
Yeah, I picture, so first of all, we would have to adopt some rules, and that each convention, there is no set way that the convention has to operate. So we would have rules that we would adopt that, assuming this legislation moves forward, that we would start working on. We can look at the rules that were in the previous conventions and come up with our own to mirror them. We could come up with our own unique ones. But I would see it similar to the way that bills move through this process, as far as that we would be able to, if I wanted to, let's say the homestead exemption wasn't already protected, and that was something that me as a delegate wanted to protect, I believe that I would be able to make that motion, or that in the form of a bill, to say, hey, we want to take this article of the Constitution and retain it in the Constitution. Or if there was some item that we wanted to move in the statute, there would be a piece of legislation that would move in the statute that we would all have to approve.
Okay. And then let's say hypothetically the convention delegates pass a rewrite, or however we want to frame it, of the Constitution. does the entire rewrite appear on the ballot, or what actually appears on the ballot for voters?
It could be a variety. It would not be the entire rewrite of the Constitution. It would probably be something very simple. Do you, in the shape of, do you support the new proposed convention or Constitution?
Okay. And are we prepared to do a public education campaign as a legislative body, or let's take the legislative body out, as a convention to educate the public, not pro or con, but to say this is the result of the Constitutional Convention. This is what's going to be before you. Will we proactively do that, or will the onus be on the citizen to educate themselves?
No, if we don't proactively do that, this Constitution is not going to pass the people. So
So they'll have to educate themselves.
No, I'm saying if we do not educate the people, it's not going to pass their vote. I think we're going to be obligated to educate the people on the new Constitution.
Thank you. Well, Chairman, thank you so much for answering my questions. Thank you, Mr. Speaker.
Representative Hughes.
Rep. Willard for a question on the bill.
Thank you, Mr. Speaker. Good afternoon, Chairman Boyer.
Good afternoon.
So in your opening, you talked about the need for us to have the convention this year because there's no statewide election next year. Is that correct? Has the legislature ever prompted a statewide election for the purpose of constitutional amendments before?
Absolutely.
So we could have a statewide election next year if we so chose to?
We could, but the purpose was we're going to have the highest voter turnout this fall, and so these special elections draw very little voter turnout, and so if we wanted to have the most votes allowed, or not allowed, but that would be cast, we thought this fall would be the ideal time to do it. It would also be in time to be able to address any kind of budget shortfalls.
Okay, and talking about the budget shortfalls, you said that is one of the motivating factors for this proposed constitutional convention?
Yes, sir.
Isn't it true that if we truly wanted to avert a deficit, we could renew the .45 sales tax and rededicate the vehicle sales tax to the general fund?
That would be an avenue to do.
Okay. So talking about the actual convention process, it's my understanding that historically delegates have been elected from the representative districts. Is that accurate?
Yes, sir.
Why do you think we are okay to avert that process for this proposed convention?
We all just got elected this fall through the independent eyes of all of our constituents. They felt the duty to call us to serve here in the legislature. This is a legislative feat, so to speak, and I think that is a perfect justification to allow us to serve. We all come from different walks of life throughout the state, different geographic areas, bring various backgrounds, and I think we are the perfect people to be the delegates. Go ahead.
Well, do you think that it would be possible that we had people in our own districts who would have chosen to be a delegate to a constitutional convention but not have the appetite to run for a state representative?
Yeah, it's very possible.
Okay. So you were going kind of back and forth with Rep. Hughes about the limited convention and certain things are off the table. Can you enlighten the body as to what currently would be prohibited if that limited convention is actually the way it plays out?
So as far as what items we've protected?
Yes.
So that's what I said in my introduction. We have Articles 1 through 4 that have been protected, and we also have the MFP and homestead exemption.
What about retirement systems and pensions?
I have not brought an amendment to do that at this time.
Okay, what about funding for levee boards and flood protection?
I've not brought an amendment for that this time.
Okay, supplemental pay, collective bargaining?
I have not brought an amendment at this time.
Okay. So once we actually get into the convention, if we say, hey, these are the rules we're going to abide by, what would the process look like if a member decided to propose a change to, let's say, the homestead exemption? What would that process look like?
I think it would be rejected on the grounds of the convention rules, which are outlined in House Bill 800.
And who would make that determination?
The presider of the convention,
Do we know who the presider is yet?
not at this time.
How will that be determined?
I'll say that. The Speaker of the House would be the initial presider, and then in rules that we would adopt, we would elect a presider for the convention.
So you would have a presider for the House, the Senate, and the 27 delegates?
At this time, we would be looking at a single presider for the entire convention.
Would that person be elected by the delegates?
Yes.
Okay. So speaking of the committees, you said, we'll maybe have some meetings over the summer for committees to start looking at some of this stuff. I really would like to have some insight as to how the whole convention process will work. Are certain articles going to be assigned to certain committees? Are those committees going to be joint Senate and House committees? Are the delegates going to be assigned to committees? Have you had any discussion about
Yeah, so
how that would play out?
Yeah, so the thought is there'd probably be two versions of your answer, two different ways that this would happen. One, between the time we convene and when the full assembly meets, there would be a committee to vet each article. Again, if we wanted to break it up into if we had enough people that wanted to participate and we wanted to break it up into different subject matters, there would be different committees. Ideally, I think some of the governor's delegates who have been helping us through the process, you've seen them in the committees. They could lead some of the testimony and the work. And once we're in the convention, I picture it as similar to how we have our own committee structure here in the House and in the Senate, to where you would have different committees vetting different articles.
So would it be like Article 1 committee, Article 2 committee?
That could be the way it would be done, yes.
So we're still not sure about that process?
Second, the members out of time, I'm going to ask that we grant an additional 15 minutes. Hearing no objections, the members granted an additional 15 minutes. Rep. Willard.
Thank you, Mr. Speaker. Is that something that could be a possibility? You
Yes.
break it down per article?
Yes.
How will members be assigned to committees? Will the presiding officer select what committees members serve on?
That would be established in the rules, but that would be the way I'd envision it, yes.
So would that look like 3 separate committees for one article? Because my understanding is you have to have a vote from the House, a vote from the Senate, and a vote from the delegates. So is that,
The way that I envision it would be a joint committee for each one of them.
so it'd be one committee for each article, but then after it comes out of committee, you would have to have 3 separate votes?
Yes, sir.
Okay. Any idea of where we're going to meet yet?
There's a couple of different, this room holds a lot of folks, but also across the street, they've reserved some space as well at one of the other buildings that holds, I think, a little bit more capacity than this room.
Okay, so you said reserve some space. What timeline are we looking at?
As far as
The actual convention?
so with the full assembly, it'd be August, no sooner than August 1st,
Do we have an end date on that, or is it
August 15th.
August 1st to the 15th?
And we would allow, the way we have it drafted is we would allow, if we have a vote to extend it, we can extend it by certain time periods if we get into a final deadline and we need to push it back. So the 23rd is the drop dead date. The Secretary of State and everyone agrees that we have to be completely final. And so I would envision it being completed by the 23rd. If not, it would miss the fall, the presidential ballot.
So the max time we would have would be
Yes.
a little over 3 weeks.
If we would go over it, if we would go over that, we'd have to consider another election date.
Okay. Now, as we talk about the proposed changes to the Constitution, will every delegate have the opportunity to make a change?
Yeah, just the same way you have an opportunity to change laws today as legislators.
So every delegate would have to do that.
They wouldn't have to, they would have the ability to.
Would we all have to take some type of oath before the convention begins?
Yes, sir. And
What would that oath
it's spelled
pertain
out,
to?
it's spelled out in the bill.
Okay. What about the delegate? Is it just related to House and Senate members, or would the delegates have to take the oath as well?
Every delegate, House, Senate, and governor appointees would have to take.
Everybody would have to take the oath, okay. And it would be a roll call vote on every proposed change at every step of the process?
Yes, sir.
Okay. All right. Are you aware, I mean, there's been floating rumors out there. Are you aware of any current draft of a newly revised constitution right now?
No, sir.
Okay. So we're working in good faith here. Do you believe that the current Constitution expressly allows a limited constitutional convention?
It's silent on it.
It's silent on it? That's my understanding as well. So are you aware that previously when a legislature tried to do a constitutional convention, at the same time that newly revised constitution was on the ballot, there was a ballot initiative to expressly allow the legislature to have a limited constitutional convention? Are you familiar with that?
You shared it with me yesterday.
Yeah, so we talked about that yesterday, and that ballot measure did fail. So my question is, if that previous legislature attempted to do that, do you think that maybe they had some doubt or concern about the legislature being able to convene a limited constitution?
I think at that
convention?
time, they were really focused on Article 7 and 8, and so that was the purpose of it. This is not just focused on that. This is broader than that. But if you all would prefer to have a full-blown convention and open everything up and not have any items protected, I think that is something people would consider. But with speaking with everyone, I have felt that items needed to be protected in order to make you all as legislators more comfortable with the idea of going into a convention. So that's the purpose of it. I'm fine with a full-blown convention personally. So I don't have a problem with that. I would prefer more things moved in the statute. But as this process goes along, compromises have to take place, and we have to make some amends if we want to see the fruit of these efforts.
All right, so I know we've heard that anything that comes out of the Constitution would go into statute and be protected by a two-thirds vote?
Yes, sir.
Is that still the plan?
So the two-thirds vote, it can be a higher threshold than that. It could be a lower, but I mean, I think everybody agrees that two-thirds is the.
So where would that be defined? Like, because right now that's not
It's going to have to be in the convention.
during the convention? Okay. So everything that would come out would go into statute, and it could be eliminated with the two-thirds vote?
Correct.
Okay. Next question is just about, I guess, timing and transparency. Do you think that this proposed bill to create a constitutional convention, do you think that it has really been transparent with the general public?
Yeah, it has. We had it sit in committee. We're hearing this bill on May 7th. We had it sit in committee over several weeks. People have had time to vet it. People have had time to give input. We had a lot of testimony on the bill. I do think this is not the convention. This is the bill to call us into a convention. And you all, and we've had members talk about the fact that everyone has had a bunch of emails, a bunch of calls, and whatnot that we've all received on it. That's public input. We had people come to committee and give public input onto this bill, not onto the convention, but things that they would like to see retained or protected in the convention, similar to homestead exemption, similar to the MFP. And so I do think there's been a lot of transparency with this process, and we're going to continue to focus on transparency for the people of the state of Louisiana.
Okay, and then on the timing front, do you think that we have allowed adequate time for the public to engage with their elected representatives throughout the state?
I do. I think we've given a lot of time for it, and we're going to continue to give more time should a convention commence. And that's part of listening to the public, part of listening to you all. There was a concern that doing this in the last 2 weeks of the session was going to be rushed. You all heard it, and matter of fact, we probably could do a poll of this room, and probably 90% of this room has said you don't like the current Constitution, but you feel that doing it at the end of session is rushed. So we heard that. So we're not going to come in at the end of this session, or we'll come in at the tail end of it while we're all here to gavel in. But then we're going to stretch out that time in the summer months. We're going to get more public input. We're going to get concerns, questions. We're going to see if there's any other items or areas of the Constitution that we need to move in the statute that we want to have protected. So the public is going to be welcome to be there. It has been transparent. It will continue to be transparent. And then when we get into the convention, it'll be the same thing. We'll have everything broadcast the same way we do here. We'll allow the public to come to the Capitol and testify. So I think transparency has been one of those things that we've been focused on.
Will the public be able to sit in on those committee meetings during the convention, like they can right now?
Absolutely.
Okay, thank you for that. So only a couple of questions left. So as it relates to the legality of the convention and any subsequent constitution that is produced, who would have legal standing in a case that would challenge the convention or the actions of the convention?
Would you do me a favor and repeat the question one more time? So
I want to know, so I want to know who would have legal standing to challenge the convention or any subsequent actions of the convention, like the production of a new constitution.
I think anyone would have that legal standing to challenge it.
So a regular citizen would be able to challenge that?
Yeah, absolutely.
Okay.
The bill, I don't know that the bill addresses that. Doesn't address that, but if there's something that is a concern with someone, I'm all ears. Neither you or I are not attorneys, so
I think I play one.
no, I feel like we all do sometimes. So if that has to be addressed somehow to spell that out, I don't see any issues with it.
Okay. Final question. So we know that Judge Dick ruled that our state legislative maps violate the U.S. Constitution, right?
Yes, she did.
So I have a question as to whether you think that a proposed convention of delegates from districts that are, violating the Constitution, do you think that passes legal muster? Do you think that puts
I
us
do.
in any type of jeopardy?
We were all elected under legal maps that were adopted by this body, by you all. We all voted on it. Judge Dick had a different opinion on it. She ruled. That is in an appeals process. The same way the congressional maps, we've now voted on 2 maps that we all thought were legal. One she thought violated federal law. One she agreed with. That one was said by an appeals court that they were overturning her ruling on that. And so we're in the same predicament. We've passed maps that this body has felt legal. And we're operating under the idea that we were all elected by the people of Louisiana. If I didn't think that we would be able to come in as legal delegates, we could toss all the work we've been doing here since we've come in. We've now come in two. So we all voted on a Supreme Court map and a congressional map as elected members. So if we go under that thought that we aren't legally able to vote on items and to participate in this process, we can throw out the Supreme Court map we just voted on, throw out the congressional maps and every other piece of legislation that we're working on. So, we're still doing our due diligence and our duty as elected officials. When that appeals process finishes, we'll address it at that time. But the U.S. Supreme Court is obviously going to have to weigh in and
Well, don't you think it's a little bit different, given that the stakes for this bill would be a constitutional convention? It's a little bit different from an actual vote from this body and starting the process for a new constitution.
As regards to the legality of us being here and serving the people of Louisiana, I don't see it any different.
Okay. Thank you, Chairman Boyer.
Rep. Hilfrey for a question on the bill.
Thank you, Mr. Speaker. Mr. Chairman, I just wanted to reiterate, and I think this was addressed in some of the previous questions, many of us are relying on the exclusions that are within the bill that you are passing when we vote for this constitutional convention. We're relying that those things that are excluded will remain excluded. Is that your understanding?
Yes, ma'am.
So that anything that were to happen in the beginning of that convention, if there were to be some movement to open up the entirety and make it a full convention, that would be in violation of the spirit of what this convention is being called for.
Yes, ma'am. And the bill gives a legal challenge to that if someone goes sideways.
Thank you, Mr. Chairman.
Thank you.
Rep. Wilford Carter for a question on the bill.
Thank you, Mr. Speaker. So, Mr. Chairman, I believe we had about 11 constitutional conventions since 1812. And all of the conventions, except the one in 93, when I was not here, but I understand there was a convention in 93.
Is there a gap when you served?
Yeah, it was a gap. I left in 92.
Okay.
But in 93, I understand that there was an effort similar to this one to changes. I think it was just two articles, Articles 7 and 8 primarily. And it was limited to Article 7 and 8. And did that convention compose of the House and the Senate? It did not compose of a group appointed by the governor, I don't think. It was the House and the Senate.
Correct.
And they produced a document,
Yes.
changes to those articles. And that went to the people. And it also had did it not, like Representative Willis said, it had an authorization to have a limited constitutional convention also on the ballot.
I believe that was a separate item, yes.
Yeah, and those two items failed. Now, all the other conventions, as best I can recall, involved, am I correct? I'm trying to see how this is different from the 93 convention or the other 10 conventions, wherein the House districts elected a delegate. And in 74, certainly, the House district elected a delegate each, so that's 105 delegates, and then the governor appointed some delegates. And those delegates met, and they came up with this constitutional convention after how many months?
They were here for a while.
It was quite a while. Okay, so two things caused me questioning this. Number one, if there's a conflict as to whether or not an item, whatever you call it, a change in the article or one of the sections of the article. For example, Article 5 has about 25 to 24 sections to it, okay? Or 32 sections to it, actually. And so each section, if you want to deal with Article 5, would have to be a separate item, a separate a document in order to change that section. Would you agree?
Yes.
Okay. Now, if you tried to change all the sections, of course, if you didn't try to change all the sections, it would be any number of sections that you want to change. Each one would represent a different instrument in order to change the Constitution.
You could word it a couple of different ways. I mean, you could have, if there was a block of items within an article that you wanted to hold tight in the amendment process, you wouldn't need to have to go item by item and amend each of those items. You could have I'm gonna call it an engrossed block.
Okay.
Section, you said 35 items, you could say sections 1 through 10 shall be retained in the Constitution.
Okay.
I don't think you have to go one at a time.
Okay, so it's your thought, Article 5, that's the judiciary article, would probably not require each section to be changed, accept some and change some.
Yeah, I think it could be either.
Okay,
is the
but
way
you don't have to do it by one instrument. You can do it by one instrument or many instruments.
Yes, sir. That's how I would envision
Okay,
it.
so each instrument would have to be heard by a committee of the delegates, right?
Yes, sir.
And that those same instruments would have to be heard by a committee of the delegates in the House and the delegates in the Senate and the governor appointee delegates.
Yes, sir.
All right, and now if there is a challenge to any one of those three instruments in any one of those three bodies, then the bill says it is to be resolved by the 19 JDC.
Yes, sir.
But what it does not say, that if you have a constitutional question, the change affect, it's a constitutional issue, it does not necessarily limit to the 19 JDC, because as you know, we can go to federal court on a constitutional question.
Correct.
Then we're going back to Judge Dix, basically what it boils down to. So, knowing that this problem, since we're going to put this off, what prevent us time-wise? I know the Secretary of State need to have things done by a certain period of time. What prevent us time-wise from going back and say, look, we're going to have a convention elected members, delegates elected from the House, like we did in '74, and some appointed by the governor. What time period would it take to make that happen? We pass a bill this month, we can have a delegate convention within 30 days or 40 days, and then we can be right back here in July and August doing a convention.
I don't think the Secretary of State is going to be able to pull that off in that time frame.
So the Secretary of State giving you a deadline date that she would have to get something for the ballot is August, what you're saying?
Well, no, that's two different items. You were talking about having I guess
Having
you're talking
delegates
about
here.
having the bill amended to allow to change the way the delegates are brought to the
Right,
convention.
right.
Have them elected and have that done in the next couple of months, and then have us enter into the convention the beginning of August. Is that what you?
Right.
Am I understanding your question correctly?
Right. Well, we're trying to get a instrument ready, a ballot initiative ready for the election in November, okay? We're not subject to the same guidelines we would have for a congressional election or, that sort of thing. We are looking for delegates. If we were to look for delegates and to be elected, would we not have enough time to select those delegates by the process we used in '74 and have those delegates seated in August to consider the amendments to the Constitution, have it ready to go in August?
Not if we wanted to get the public input that we've all been talking about. You'd forego any public input, and you'd take all the voice of the delegates only, and would bypass what we're talking about.
Okay, so you talking about the road show. So the road show, every section of this Constitution would go to be involved in a road show or a hearing here in the Capitol.
Right, so,
You make it sound like we're going to actually go on a road show, but you're really not saying actually a road show. We hadn't decided that.
That's
but we
correct.
have an opportunity to vet it with people coming to the committees.
If that's something we decide, yes, or it can be in the committee structure where, like we have now, and receive public input. And I'm just to be devil's advocate, not for any other reason, but, with all the different, and I realize this is a little bit more important than every single one of our bills, but we don't go on a road show to hear the budget or HB2 or any of those items. We hear it all in this body. And so if we as delegates would decide that we were hearing it all here in the Capitol, I think that's still fair and get public input.
All right, so you're not aware of proposed constitutional articles written, proposed, or conversations, or any writings involving possible articles that have been produced at this point by any group?
There's no draft of a constitution
Okay,
out there, no.
so let me ask you this. I saw a document that was requested, Freedom of Information was requested from the executive branch, and it said that they refused to answer provide the information on the executive privilege, and that 4 of the requests was refused on the legislative privileges. So why would you exercise executive privileges and legislative privileges on requesting information about possible constitutional convention issues if you don't have something already prepared?
Yeah, so I'm not sure what request you're asking about, so.
Are you're not familiar with requests being made for information regarding the Constitution, proposed constitutional articles?
We get requests all the time for those items, and it's our right as legislators to. I'm not sure who did the rejection on it. So there's been times when I've rejected it. If it's something to do with a bill that I'm working on, a lot of times I'll reject it as well, just because it's part of what we all have, legislative privilege. And so I feel that's important for all of you all to be able to deliberate under the guidance that, hey, this is what we're called to do, and to have to release that every time we have a deliberation amongst each other would be unfair to all of us. So to the specific request you're talking about, I'm not sure. If it came to me, I would have rejected it, because if it had something to do with House Bill 800 and it was something that I was vetting in the process, if that's what you mean. I'm not sure. I don't know the specific request that you're asking about, or if it even pertained to me.
Okay, it was request to provide information on the Freedom of Information Act regarding any preparation that's been done, any work's been done with regards to possible changes in the Constitution. And the response was, there were several requests. The response was to about 6 of them, executive privilege, and not given. And response was to 4, legislative privilege. And I'm not getting to,
If you-
I'm not getting into the whether or not it's a legitimate legislative privilege or legitimate executive privilege. I'm not getting into that because it may very well be. But my concern is, one would probably answer if nothing has been done, there's no work been done, so there's no information to give.
You can, I can't control your speculation.
All right. Well, that just throwing that out there. Now,
Rep. Wilford Carter, the member's out of time. Is there an objection to granting an additional 5 minutes? Hearing no objections, the member has an additional 5 minutes.
so the way I understand, we would work prior to in June, we would come up with some layout, some proposed instruments of this new constitution in committee, and then we go to the people. Or do we do it in August, just vote on it in August?
So in June and July,
Uh-huh.
we would have hearings to discuss, take public input, and these committees would report back to the convention itself when we all meet as a full assembly. That is how.
So we have to have something to have the people to look at, for them to comment on. But in June, we have to have something prepared for them to look at.
I mean, you got the Constitution. I mean, they
Oh,
can look
so
at.
your vision is that we would start with the Constitution articles we already indicated we may change, have the hearings with the people and ask them how they want to change it, and then after that, come up with specific instruments to change.
I'm sure if legislators or delegates are engaged in the process, they will come to the committee with thoughts of their own on what they would like to see retained and what they would like to see moved to statute. So I don't know that it would be from scratch, but I mean, to a certain degree, it kind of would be, to where if I might have it, if myself and Representative Thompson come from different parts of the state, we have different ideas, I might come in and say, hey, I need to protect this item as it relates to some rural deal, and he may agree or he may disagree, but I mean, and then we get the public input, just like your normal committees would be. I mean, the way I prepare bills, the way you prepare bills, we bring them to a committee and we make suggestions, we'd still be able to go through that.
But we don't have people come to the committee without a bill, an instrument for them to look at and make comment on. You talk about you're going back to the original Constitution.
That's
But it's obvious there's an effort to make specific changes, and so I would have thought the changes would have been recommended, and then the people can comment on these changes by coming in and testify like we do in committees in the House. But this is not what's going to happen.
That's what the convention is for, Judge Carter. I mean, that is what we're going to the convention for.
So the people is not going to get a finished product to comment on until after the convention is completed in August 15th.
Well, exactly. I mean, you wouldn't have a final comment until you finish deliberating on what items you want retained in the Constitution to move the statute. Or if we came with a finished product, the argument would be, hey, you've already done all the work and you just want us to rubber stamp. You can see by what we've already done, protected and wanting to retain in the Constitution, that we're taking public input. So we need to continue taking public input. What you're suggesting is to block, both suggestions have been to block out public input. We want to receive public input.
I just want public input after the product is completed, before they have to vote on it. But anyway,
The ultimate public input is going to be at the ballot
at
box.
the ballot, but they're not going to be able to sit down and talk about what we did until they get ready to vote. It's going to talk about a large document. Anyway, another point I have, that get down to this point. All right, so it's my understanding there are about 32% Republicans in this state, voters. You agree?
Okay.
34% Democrats, about 32% of non-party independents, okay? So if that's true, how many independents and non-party we have in the Senate and the House?
I think we no longer have any independents.
No, have independents in the House, and I don't know if we have any in the Senate. No party, all independents. A third of the voting public, okay? So these people will not have any input in this convention until we present them with a constitutional amendment.
I completely disagree.
All right, so what input would they have?
They would have input like every other citizen in the state of Louisiana.
But they're not going to have a completed instrument until after August 15th.
but they have the ability to have public input the same way the rest of our constituents have. Just because there's nothing in this bill that prohibits folks with the independent party or no party from participating in the process.
They can come and talk about how they would like to change the Constitution, but there's going to be an effort to make specific changes by leadership in a Constitution for the good of the state, I'm understanding. They're not going to find out what that is until August 15th.
Representative Carter, when I receive questions and comments from constituents, my first question back to them is not what party you're in, is to address whatever their concern is. Republican, Democrat,
Well,
Independent.
Rep. Carter, the member's out of time. Is there an objection to granting an additional 5 minutes? Hearing an objection. All those in favor of granting an additional 5 minutes, vote yea. Those opposed, vote nay. Madam Clerk, please open machines. Members, vote your machines. Desatel, nay. Members, vote your machines. Mena, yea. Weibel, yea. Knox, yea. Cormack, yea. The clerk will close the machine. We have 54 yeas, 39 nays. The member has an additional 5 minutes.
And thank you for that opportunity to continue to debate this bill. Perhaps you agree this is probably the most important thing we're going to do in the past since 1974. This convention is going to impact people for the next 50, 60 years at minimum. Do you agree?
We hope so.
So if we can't do a ballot thing, election of people to serve in the House and Senate, and a majority vote will decide whether or not the instrument move on each section, okay? And then we go to the people in August with the proposal. That's the plan.
Yes, sir.
Okay. And if we got on this committee, to hear one of the articles, everybody would have an opportunity to serve on a committee, and all the delegates would have an opportunity to serve on a committee.
Yes, sir.
Okay. And that delegate can offer changes to the Constitution.
Yes, sir.
Aside from whatever the public may suggest, the delegate make changes.
Yes, sir.
So we would have to have our staff, like we do on our bills, our staff write these bills up, okay? So our staff are going to be, whatever the staff of the convention is going to be writing the convention bills up.
Yes, sir. And we also have to allow input with the law schools throughout the state as well.
Right. So you have an idea when this product will be made available to the delegates for them to select what they want to do. So this is going to be doing June or July or August, the 1st of August, August 15th.
I'm not sure what you're asking, Representative Carter.
Okay, so somebody going to write up an instrument. Somebody going to do an instrument saying changing Article 5 or Section 16 in some kind of a way.
Okay.
That has to be prepared by somebody, some staff, okay?
Right.
So that staff is going to, as a delegate, when I come in and whenever we start this June 2nd, and I want to an instrument to change Article 16 or Article 5, Section 16, I can do that at that time.
So those committees, that will be to take public input and to vet the legislation, and then ultimately to make a recommendation to the full assembly. I would imagine that the final bills themselves, I'm going to call them a bill for lack of better words, that would all happen during the legislature. I think the way that we envision these substructure or these committee structures to work is they would make a recommendation to the full convention, and that's where the bills would be actually drafted.
Okay. The date between August to the 1st to August 15th. Okay, thank you.
Thank you.
Thank you, Mr. Speaker.
Rep. Mandy Landry for a question on the bill.
Hey, Rep. Boyer, I'll try to read my handwriting right here. So, first of all, since we came here, I don't know if you know this, the first session in 2020, 31 amendments have been proposed, 19 have been adopted, including a few by you on both sides of that. About 14, 15 The ones adopted are by people still here, so aren't we part of the problem?
Yes, ma'am.
Okay, because I keep hearing that there's so many amendments and voters have approved so many amendments, but voters ultimately have the choice here if they want to say yes or no. So why are we not trusting them? Sorry, I was compound. Why are we not trusting their decisions for all to pass all these amendments?
So a couple of things, when again, saying that we're the problem, we are, these amendments that we're adding are adding to the bloated nature of our Constitution. I agree with that. But they are not being brought to cause problems. They're being brought to try and address other items that are either protected in the Constitution or to get around, either to change items that are protected in the Constitution, to add something else to be protected in the Constitution, or to get around the governor's veto. So these are the different reasons why they bring it.
Right, because last year, voters did approve an amendment that had been brought 2 or 3 times about voting. And my understanding is the author last year brought it to avoid the governor's veto. If you know what I'm talking about, that's correct. If you find out that there's a draft soon, are you going to tell us?
There's no draft of a Constitution.
All right, people out there say different. I've heard a lot about there's too many words. Is there a goal amount of words?
We have not discussed a goal amount of words.
Okay. I've been hearing that there's been a lot of individual meetings between legislators and the governor's staff. Has that occurred?
Yes, ma'am.
Okay.
I met with the governor earlier today.
Well, you are more important than some of us. I do hear from constituents, and obviously New Orleans voters are a little different than what y'all hear about. And I've kind of been describing it as a pinky swear, because we can put almost anything we want in this statute, and aside from, I think, the date and the amount of delegates, everything else can be changed. Is that right?
I disagree. Again, I know that the debate exists. I'm not conceding to the arguments that are being made. This is our legislative intent. And so with legislative intent, and you can speak more to it as an attorney than I can, but it's used in court. So the legislative intent of this body would be to bring a convention and not include certain items in the discussion to move into statute. That would be our intent. My intent would also be to adopt something similar as soon as we come into the convention to say, hey, these items are going to be protected in the Constitution, and these other items will be moved into statute.
Okay. So I'm sure I've brought this up before and other lawyers have. When there's confusion about an issue, first the court looks to black and white, the words that are used, and then they go to our intent. When I read the constitutional provision that applies to revising the Constitution, my view is that we can almost do anything we want when we get in there, but is your view and the people who helped to draft this that we will not be able to?
Correct.
Okay. I've also heard that, okay, I'll tell you what I heard. I heard a lot of things. The main thing I've heard that we're planning to do here is touch financial issues, taxes and entitlements and things like that. But there's one thing I heard that was different, and that was that we might be trying to change the way the Constitution is amended, which I think some have mentioned. Is there any thought, discussion, or intention on how we might change our Constitution change the right or process of amending our Constitution?
Yeah, the thought, and I've heard arguments on both sides of this, so the discussions that I've been involved in is looking at the possibility of adding a voting threshold that would make it more difficult to add constitutional amendments.
Like
to the ballot.
60% or something?
Something, or different states do different items. We're researching that as we speak to be able to present it to the convention. And to, there's some states you have to bring a constitutional amendment more than 1 year in a row. You have to bring it multiple years, and that's to pass by certain voting thresholds. So that is a valid way that we can approach it. There's been some argument that would be too onerous, and if there's some federal law change that we need to adopt or something else that we need to act swifter, that might having it stretched to 2 years would be different. But there's all kind of different ways to skin that cat. But that has been a valid discussion that we've had. The voters, and you all probably get it back home, every time we have the constitutional amendments on the ballot, they're asking us to interpret what they say. And if it's been a little while since we've been in session, even a lot of us are having to revisit and try and remember what these amendments. So if we could lessen or eliminate the constitutional amendments that are on the ballot every fall, I think our constituents would be much appreciated.
Well, that would just change the percent to pass it, not necessarily how many. But also, just asking that, I agree that a lot of times it's too complicated, but that's us who, we determine the words on it.
No, I agree. I mean, it's the Civil Law
Yeah.
Committee.
What about a ballot initiative process? Has that been discussed?
It is not.
Oh, I can't wait to offer an amendment on that.
I figured as much.
My sweet meat over here, we've been talking about coastal issues, so I'm gonna ask for him. Has there been any specific discussion about coastal protections?
None
That you know of?
specifically, no, ma'am.
Okay, I'm almost done. Oh, the provision to give the governor 27 delegates, is that just something that we're gonna agree to in this? Or is there, beside what happened in 74, is there any other reason to do that?
That's where we gave the number. The governor had put together a transition team to look at the constitutional revisions, and this has been his, it's his committee or his transition team's initiative, and to have him give him a seat at the table, I've been very open to, and ultimately, if any of us wanted to just to bring a bill without the governor's support, we'd all be willing to do it. This one included the governor's support and was brought to us with his transition team's members' intentions, and so I thought it only fairly right to give them a seat at the table.
But like you said earlier, redrawing a constitution is a legislative function. So while I understand people, want to give the executive branch input, we don't have to.
We don't, but I mean, you can, if you take that argument, then take Judge Carter's argument about only having the legislators do it, but mirroring off of what they did in the 70s, where you had the 27 delegates. A lot of this you can argue either way. If you're not in favor of the convention, there's a lot of different ways to throw holes at it. And to
You don't think those holes are valid legal and principled arguments?
none so far.
Some of them. You talked about public input, but I think that was just committee hearings, right?
Committee hearings and committee hearings during the convention.
Okay. And we received, and I've seen others, letters in support from healthcare systems and university systems, and they all get money from the state, right?
They all get money from the state, yes.
Yeah.
And when we have budget cuts, it ends up on the backs. There's a lot of entities throughout the state that get monies from the state. So that's part of what we're here talking about.
All right.
K through 12 gets money from the state. Higher ed gets money from the state. University, the Medicaid system is state and federally funded. You touch every corner of our state dollars end up, all of our municipalities receive capital outlay and direct appropriations. So in every nook and cranny of the state, we are sending state dollars to them, which I think is, part of the issues that we have to some degree.
But for them to, my opinion, for them to very publicly state they support the convention at least implies that they think they're going to get increased funds.
No, I don't think this has anything to do with
No?
them getting increased funds. I completely disagree. I think what it's saying is whenever we have the budget shortfalls that we expect, and that they get the fair shake and treated the same as everything else in the that we fund.
Okay.
Rep. Landry, the member's out of time. Is there an objection to granting an additional?
I have one more question, that's it.
Objection to granting an additional 5 minutes? Hearing no objections, the member has an additional 5 minutes.
Thanks. I just have one question. I forget who said it, that, or maybe it was you. Part of the reason, or most of the reason for pushing this now is to have it on the November ballot. And what I've heard was to have it on the November ballot when former President Trump is on the ballot. And I don't know if you've heard that specifically.
It would also be on the ballot when current President Biden is on the ballot.
But did you hear specifically about former President Trump being on the ballot?
I believe he is the Republican nominee.
That wasn't my question, but thank you for answering.
Rep. Marcel for a question.
Thank you, Chairman Boyer, for enduring all of these questions. You know, as you know, I serve on H&G, and we had many of the questions.
I know you're on the committee, Representative Marcel.
Good. And I just want to publicly thank you for hearing some of the concerns and some of the things that you took care of, the MFP and the homestead exemption. And further, I want to make sure that I got this correct. The private companies that was in the bill to give money for the convention, that's been taken out also?
So there was no private companies, so to speak. There was no companies that were given money. We were similar to other conventions. We originally drafted this bill mirroring off of other convention bills where we allowed outside dollars to fund the convention. We amended the bill last week to remove that language, so there would be no private outside dollars allowed to fund the convention.
You call it outside dollars, private, outside, whatever, but I appreciate
It
you.
could be the reason I'm pointing it out because it could be an individual, it could be a company.
Right, I understand, and I appreciate that. Some of the questions that I continue to get is we're protecting Articles 1 through 4, but we haven't said much about 5. Do you believe that with this constitutional convention, there could be a process where something happened with the judicial seats and the number of judicial seats as we currently see them?
I haven't heard anything to speak of.
But could that happen?
The way the bill is drafted now, yes.
Yes.
Yes, the way the bill is drafted now.
So it could potentially happen that we could get more specialty courts and the other courts would not handle those matters? Could we add judicial seats and take away judicial seats with this bill?
As it's currently drafted, yes, we could.
Okay, and that was some of the concerns that I had.
What we would, so let me give you a technical answer on that. This bill does not allow it to get rid of judicial seats. What this bill would allow you to do is to move that item into statute, which then would require a 2/3 vote to make any changes to that. So that's the technical answer. We have that higher threshold once things are in statute. So we're not getting rid of anything. It would not be retained in the Constitution, to your point.
Yeah, you continued to say, and the people who came to the table, that we were not changing anything, but we were moving it. And so is that still your understanding that nothing's going to change? We're simply moving it out of the Constitution into another part of the statute?
Into statute, yes, ma'am.
And once that item is removed from the Constitution, is it your testimony that at that point, then any legislator in here could file a bill and change whatever that is? So, I mean, we're saying on one hand that we're not really changing anything, we're just moving it. But once we move it, is it your testimony that we could then change that?
With a higher voting threshold is the intent.
You said a higher, it wouldn't take,
So like a 2/3, so, and a couple of people said they didn't like the terminology. I don't necessarily like the
I
terminology.
don't like the terminology either.
But a super statute, so to speak, kind of like our money bills, where they would require a 2/3 vote to be removed out of statute once they're in. So we have an item that's in the Constitution. It's moved into statute. Once these items in statute, they'd be protected by a higher voting threshold once they're in statute. So it's not easily removed. So
It may not be easily removed, but would you agree that once it is moved from the Constitution, then it would take a simple majority to change anything about it?
no, ma'am, that's what I'm saying. So we
Why
would have
not?
we would have that higher voting threshold to remove it from statute. That's what we've been talking about in committee for 2 weeks.
Yeah, I understand removing it, but once it is removed, that's my question.
We would have a higher voting threshold and protect it in statute, so it's not easily removed from statute.
And what's that threshold?
That's what we're talking about. A 2/3 vote is what we've been discussing.
That's what we discussed, but there's nothing in concrete right now, right?
No, that's not just because we're still going through this process. If we wanted to add something to have that two-thirds language, I don't think anybody has an issue with it. And if, whether it's done here or done in the convention, that is definitely everyone's intent.
One of the other questions that I had was why didn't we do a road show or go around the state? And I heard you mentioned it earlier that could be a possibility. Tell me what that would look like.
So as it relates to the establishment of a committees to take public testimony, that public input could be done here at the Capitol, that public input could be done in a roadshow fashion as well.
But there's no commitment to do a road show at this time.
We've talked about it, and we just, general public input, the committee setting. I wouldn't have any issue with doing a roadshow. We've done them in the past, but nothing in the bill says this, we're going to conduct a roadshow, we're going to have this amount of meetings that we're going to conduct on the road. We don't have that drafted in this bill.
You don't have that drafted, okay. So that's some of the emails and concerns that I'm getting from people who may not be able to get to the Capitol.
And
Concerns.
So the same way you're getting those emails and concerns and you're reading them and you're articulating them now would be the same way if again, whether we do it, I'm not saying we're not doing a roadshow, but if we would be having hearings here at the Capitol as a centralized place, as you receive those emails, you would still be able to voice the concerns of your constituents here in Baton Rouge.
I understand, but I've been on a few of the road shows, and so I understand taking it to where they are is a lot easier for the people of Louisiana. Let me move on to Article 10. I've heard you say a couple of times, you said that there are no written provisions currently. Article 10 deals with the civil service protection and retirement.
There's been nothing added to this bill in that fashion, correct?
And nothing added, but so there would be a higher threshold if we removed something from the statute under Article 10 and placed it in the regular statute.
If we would remove something out of any article and put it in statute, there would be a higher voting threshold. Whether it's Article 10, Article 9, any of them would have the same treatment. There wouldn't be a special treatment for one article or the other. It would all be a higher voting threshold.
Okay, so have you heard those concerns about the civil service, or am I the only one?
No,
hearing those
I've
concerns?
had concerns. I've heard the concerns. I haven't had a lot of detailed discussions on them, but I've had people ask questions about civil service. Same thing on the retirement side of things as well.
Okay, and you believe that if we hold this convention, that it will be done fairly and everybody will have input and some opportunities to say whatever they feel should be moved and should not be moved?
Yes, ma'am. I don't think in this building we've had anybody not feel that they aren't able to provide the input, same whether it's us as legislators or from the public.
And currently, is it your testimony today that we're moving it to August and no longer going to be done in June?
The
to
bill
July. Initially, it was from
bill is
June to
amended.
July.
The bill is amended, would call us in no earlier than May 30th into a convention, and then would allow us to set up the committee in a formal convention setting and have the public testimony, and then we'd come in a full assembly no earlier than August 1st, and our Speaker of the House would be the one to call us in to both of those items.
How long do you think that would take, the convention itself?
The convention?
Yes, sir.
We have it the way the bill is drafted now. The full assembly we would come in on March 30th is the earliest, and finish no later than August 15th. So those are the time periods.
I'm sorry, I can't hear it.
The full assembly,
The member's out of time. If you would like to grant an additional 5 minutes, is there an objection to granting an additional 5 minutes? Hearing no objections, the member has an additional 5 minutes.
so the way we have it drafted now, after the amendment was added, the full assembly would come in August 1st, and we would wrap up business no later than August 15th, unless we vote to extend it.
Okay, but we could vote to extend it.
Yes, ma'am.
And the hard date of August 15th is because we're trying to get it on the ballot for
The Secretary of State have given us a hard date of August 23rd, and we're using the 15th as time to give us some wiggle room and to give the Secretary of State a little bit more flexibility. But we do know that it can go all the way into August 23rd if needed.
But if we are unable to accomplish that date and that
Extend
deadline,
it.
we could just
You bring
do
up a
this.
valid point. So if we get to August 15th or even August 23rd, we have the ability to extend it. Now, if we extend it, we may be extending the time frame and it would end up on a different ballot, you know, the runoff election or a spring election or something else. But that's a whole nother can of worms there. Our intentions is to wrap up on August 15th, give the Secretary of State enough time so that on August 23rd, she is able to have us ready for the election.
I get it. But my final question would be, you know, I heard testimony in the committee that is taking them years working on this constitutional amendment for a number of years, and I'm just trying to figure out how do we get there in such a short period of time. And let me be clear, it's not that I don't think that we should do it. I'm concerned about the time constraints.
No, and I appreciate that, and to that point, and to the testimony we received, to your point, to the testimony we received, that's why we have moved the dates and extended it to be able to receive public input, to be able to put together these items for the convention, to be ready for it, to have all the delegates ready to conduct business of the full assembly when it does. And I think it is a testament to what we've done as a body, listening to public input and then stretching out the time to be able to allow that. So we've gone from what everyone had issues with, from a 2-week period to a 2.5 month period for the input, and so it would not be rushed. We would have significant amount of time to be able to make this happen. But
Thank you.
One other item on that: we are not rewriting the Constitution. This is a refresh of the Constitution. This is a refresh of the Constitution. We respect the previous author's work so much that we're going to retain that language and simply move it into statute. So what took them so long was they were debating over every comma, every word, and rewriting the entire Constitution. This is not a constitutional rewrite. So we're taking that language that's in it and move it into statute, saving us a tremendous amount of time in the process, therefore being able to do it in an expedited fashion, like you mentioned, while allowing all the public input.
So is that what you mean on page 5, line 4, where you say renumber or rearrange provisions?
Yes, ma'am.
Number 2, transfer or divide provisions?
Yes, ma'am.
Number 3, change reference designations to conform to redesignated provisions?
Yes, ma'am.
And finally, number 4, make any other purely formal clerical changes in keeping with the purpose of the revision.
Yes, ma'am.
That's what you mean.
So this is stuff that I've worked with staff on to try and give us the ability. So as you change the Constitution, there are a couple of things. There are items in the Constitution that are outdated, that expired under certain times, that can be moved into statute without an issue. As these items are moved, numbers are going to change, bullet points are going to change, and so we've used the language to not affect the effect of the provisions and what's in the Constitution, but allow for us to, if we need to clean up like wording in it, to give us the ability to do housekeeping in the process, but not changing the effect of the Constitution, if that makes sense.
Thank you. My final question would be, if there is some type of legal suit filed, that will go to the 19 JDC.
Yes, ma'am.
And I think that in this particular piece of legislation, you all asked that they move swiftly and put it on a preferential docket.
Yes, ma'am.
Is that
I
accurate?
think swiftly is a legal term.
Okay. Yes, sir.
Yes, ma'am.
But I guess what happens if it doesn't get heard? I guess it just pushes it back some?
I would think so.
An appeals process would take even longer?
I would think so.
Okay, thank you for answering my questions.
Thank you, Representative Marcel.
We have no further questions on the bill. We have some amendments for the bill, Madam Clerk.
Mr. Speaker and members, Representative Wilford Carter offers up set number 4064.
Rep. Wilford Carter on your amendments. Members, please keep your conversations down.
Thank you, Mr. Speaker. Remember, this is a simple little amendment and has to do with Article 5 of the Constitution. And it basically, I let the clerk, you read it already? What it does, it says that you cannot change the district court's jurisdiction in Article 5 of the Constitution. And that's Section 16. Article 5, Section 16 has to do with the jurisdiction of the district court. Now, in the past, we have created specialty courts. And those specialty courts were created within the authority of the district court that presently exists, the jurisdiction of the district court. And that's all this amendment is attempting to do, is that we not change the jurisdiction of the district court. And if we created new courts, they would work within the present district court jurisdiction authority. I answer the question.
Rep. Wright for a question on the amendment.
Thank you, Mr. Speaker. Representative Carter, Judge Carter, are you saying that with this amendment, you're going to support the Constitutional Convention bill?
No, I'm not saying that. I'm saying to make it a much better bill. For me, it would give me some comfort that we're not going to go and do something that's going to destroy a lot of effort of what we've gone through and got to this point in terms of what is the statutory authority of the district courts.
So you're just trying to make it better,
I'm trying to help the people
but
in this
you
state.
won't. You're not voting for it.
I didn't. Well, more than likely I won't vote for
I
this.
appreciate you just trying to make help.
And
I appreciate
I'll tell
it.
you what my problem is with this process. But as to this amendment, I think it's a good amendment for the judges that presently are working in this state, have been elected judges, and they are in the district court, and they have jurisdiction. And we have changed to specialty courts throughout the state, but we have not interfered with the jurisdiction authority of the district court judge as it presently exists in the Constitution.
Appreciate you trying to make the bill better, or trying.
Rep. Willard for a question on the amendment.
Thank you, Mr. Speaker. Rep. Carter, have you heard during this discussions of HB 800 that if we had certain things that we want to make sure are off limits, then we should propose amendments
That's
to
correct.
HB 800?
That's correct, and this is one of my concerns, and I think others as well.
And so you're just trying to make sure that something that you want constitutionally protected remains constitutionally protected in the case that we do abide by the guardrails laid out in HB 800?
That's correct.
Thank you.
Thank you very much.
Seeing no further questions on the amendment, is there any objections to the adoption of the amendment? Rep. Boyer for the floor.
Members, I object to this amendment, not because I have any issues with retaining items that are in the Constitution as it relates to the judicial branch, but as we go through the process, I want to make sure these items are things that get you comfortable with this bill. Adding this item does not give Representative Carter comfort with the bill, and so I'm going to object to the amendment.
Rep. Boyer, were you taking any questions are waived? Rep. Carter, you have a right to close on your amendment.
We have gone through a long process of developing our court system in this state. And I was fortunate enough to be involved with it back in the early 90s, pursuant to a court order. And we have had our relationships with the court in trying to reapportion the judiciary. And as a result, we have a finished product that has certain jurisdictional limits. And those jurisdictional limits has been a process. For us to destroy that, take that away, and start over again will put this constitutional convention in jeopardy with federal law. And so you have folks running the court in the federal law saying we're doing something by this constitutional convention that was already worked out either jurisprudentially or by reapportionment. And I'm afraid that might be an effort to undo some of the courts that we have already developed and organized and been protected in the Constitution. And so even though we have changed the sections of courts by statute, 2/3 vote. We have not changed the jurisdiction of the court. And so I'm hoping we don't change the jurisdiction of court. If you do, and you create other courts that are doing the same thing the district courts are doing now, without the jurisdiction authority of the district court. You can still create different courts, especially courts, but it should be done like all other special courts up in this state under the authority of the Supreme Court and the district court that they function in. That's all this amendment seeks to do, is to avoid any future litigation as a result of changing the jurisdiction of the court.
Okay, members, Representative Wilford Carter has offered up an amendment to which Representative Boyer has objected to. All those in favor of the amendment vote yea. All those opposed vote nay. Madam Clerk, please open the machines. Members, vote your machines. Davis, nay. Boyer, nay. Jordan, yea. Members, Green, yea. Members, are you through voting? The clerk, Desatel, nay. Emerson, nay. Members, are you through voting? The clerk will close the machine. We have 32 yeas, 70 nays, and the amendment fails. Next amendment.
Representative Wilford Carter offers up set of amendments 4065.
Rep. Carter, your amendment.
Okay, thank you, Mr. Speaker. If you didn't like that one, you probably won't like this one either. This is a protection of the Court of Appeals. The Court of Appeals, the Constitution provides a certain number of minimum sections that you got to have in courts of appeals, and it provides jurisdiction for the courts of appeals. This amendment protects that. And so I offered, for the same reason, I offered the earlier amendment on the district court.
Representative Wright for a question on the amendment.
Thank you, Mr. Speaker. Representative Carr, have you rethought about supporting the bill?
I got my button pushed for the floor, and I'm going to tell you what I think about this bill when I'm recognized. for that
Understood.
purpose.
So
I'm
I
only dealing
assume
with-
then by this amendment, it doesn't change, you're still voting against the bill.
I will tell you what my position is on this bill when I take the floor on the bill. I'm just doing this amendment, and I think the amendment is an important amendment, and if you really intend to not do any damage to what's been accomplished in the state already in the judicial article, then you will vote for this amendment. And I don't see how the Court of Appellate jurisdiction going to affect specialty courts unless you plan on getting around the circuit courts in order to get straight to the Supreme Court, which is specialty courts. I've heard all kinds of things. I'm just trying to, what I'm doing is speaking for the public. This Wilford Carter has been practicing law since 1975, okay? And I'm still practicing law. I retired as a judge a long time ago. So this is the protection of the people's court that has been working just fine in this state. And if some folks got a problem, got a real agenda against the court system in this state, then they ought to, this gonna force them out. As whether or not, we're going to find out right now, just like we did at the last amendment, what are you planning on doing? What is the leadership plan on doing? What is the powers that be plan on doing with the courts of this state?
So
I heard some terrible things about specialty courts. I'm generally for specialty courts, but I'm not for it if it's going to take away jurisdiction from the district court or the appellate court. We already spoke on the district court. This is the appellate courts.
Representative Carter, I would argue that there's all kinds of statements out there like that, and I've heard nothing about courts being affected. And I think you'd probably be more effective dealing with courts in a constitutional convention than speaking up then, as opposed to putting up amendments when you're going to vote against the bill. Anyway, that's just, my take on it. But my point is that we have a lot of groups out there throwing stuff against the wall that no one's discussed. We haven't talked about rewriting a constitution. We haven't talked about a variety of things, and trust me, I'm going to come to the mic on this anyway. And now all of a sudden we're putting up amendments like we're going to do something that no one's talked about. So if you're not going to support the bill, I understand, but I appreciate it.
You might not talk about it, but a lot of people talk to me about it.
Rep. Carter, 1 second. Rep. Schlegel for the floor.
I'm going to recuse myself from this vote per the rules of the House.
Without objection. Okay, members, Representative Carter has offered up an amendment. Or any objections to the adoption of the amendment? Rep. Boyer for the floor.
So members, on this objection, For the same purposes, I have no issues with the judicial system, and we have a great judicial system in the state. But as we go through this, we're trying to build a better bill to make you all more comfortable. And if there are items that we're presenting that are not bringing that comfort to you, I'm going to continue to object. Thank you.
Rep. Boyer, will you take a question on your objection? He waives. Rep. Carter, you have a right to close.
Here again, we say that there are some things that's important enough to take out. We've done that. We had other amendments. It's not the first amendment. And this amendment seeks to protect the jurisdiction of the district court, the Court of Appeals. And Article 5 is apparently at risk. It's not been one of the first four they say they're not going to touch. They're going to touch Article 5. I don't know how they're going to touch it, but some of us not going to like it. And so to avoid that controversy, we can at least agree that the jurisdiction of the Court of Appeal would be the same now and after the convention. That's all we're doing. And it's not saying you can't make changes to the Article 5, because I would like to see Article 5 completely taken out. But if you want to make changes, don't make change to the jurisdiction. If you're going to create a specialty court, have that specialty court be appealable to the circuit courts. And so I offer the amendment. Now, a lot of times, don't think I get up here thinking this stuff's going to pass. My purpose in doing this is to make a record. And you make a record for one reason, in case you need it later on. I'm making a record. So I've offered this amendment in good faith to protect the course of appeal, Article 5, and I'm afraid it's going to be attacked because special interest wants to make some changes in Article 5. I have a real problem with that folks want to create courts that present district judge will not be able to hear those cases. Why? And it's a result of many years of complying with Section 2 of the Voters' Rights Act. And we want to undo some of that by doing this constitutional convention by people that are influenced by special interest groups, worrying about the next election. I think it ought to be people that are running for one purpose only, to do a...
Rep. Carter, I'm asking you to stay on your amendment. Will you take a question on closing?
Amendment. But
will you take a question
Mr.
on
Wright
closing?
got me going.
Rep. Carter, will you take a question on closing?
Yes, Mr. Speaker.
Okay, Rep. Thomas for a question on closing.
Thank you, Mr. Speaker. Representative Carter, did I hear you say that you would like to have Article 5 out of the Constitution?
Out of any changes to the Constitution.
I think I heard you say out of the Constitution.
Out of any changes.
Thank you, Mr. Speaker.
Make it clear, I don't want any changes made to Article 5.
Okay, members, Representative Carter has offered up an amendment which Rep. Boyer has objected to. All those in favor of the amendment vote yea. All those opposed to the amendment vote nay. Madam Clerk, open machine. Members, vote your machine. Members, vote your machine. Green, yea. Davis, nay. Members, are you through voting? The clerk will close the machine. We have 29 yeas, 71 nays, and the amendment fails. Next amendment. Members, we have a lot of amendments, so just, if you don't mind, stay put. Look at your computers to see what's coming up next. Madam Clerk.
Representative Phelps offers up set number 4068.
Rep. Phelps on your amendment.
Mr. Speaker and members, at this time, Representative Phelps moves to withdraw set number 40.
Without objection.
The next set of amendments. Rep. Marcel, do you mind coming to the desk, please?
Rep. Marcel, can you come see?
Representative Marcel moves to withdraw set number 4078. Next set of amendments is offered by Representative Phelps. That's set number 4081.
Rep. Phelps on your amendment. Rep. Phelps on your amendment.
Thank you, Mr. Speaker. The first bill, the first amendment, Article 743 is, I was asked about our ports, asking for that portion of our Constitution be kept intact as well, and ask for your favorable passage.
Rep. Wright for a question on the amendment.
Thank you, Mr. Speaker. Representative Phelps, does this mean if we amend the bill, you'll be supporting it?
That's not the question here. I was asked about my porch to bring this amendment last week when we were trying to protect some of the interests across the state, and this is why I'm bringing this amendment.
Okay, I take that as a no then. Okay,
You
I
can take it
understand that.
however you say it, but I just told you that I was bringing this amendment for the ports, and this is not about how I'm voting.
I know, and I just asked a question. Does that mean you're supporting the bill? And you said no.
And I did not tell you that. What I
Okay.
told you was I was bringing this bill.
So
this amendment-
it's fair. If you don't want to ask the question, I understand.
Now you see how that feels. Has nothing to do with me in the voting on this
See
bill.
how
It's
what
this amendment.
feels? Tell me now.
When
I'm
you-
not
your
sure I
question
understand what
is
you're
not
saying.
answered, when your question is not answered, the way that you want it to be answered. We do that a lot in this building.
Oh, yeah, we do.
We do.
I can't really say I pick up the mic that much to ask this
Y'all
kind
don't
of
mind,
question. Thank
please
you.
stay on the
Are you going
amendment.
to, thank you, Mr.
Rep.
Speaker.
Rep. Willard for a question on the amendment.
Thank you, Mr. Speaker. Rep. Phelps.
Yes, sir.
As we've heard more and more about HB 800, have you heard that if there is something that we want protected in the Constitution, then we should run an amendment to do that?
Yes, sir, and I did this on last week.
And this was filed last week?
Yes, sir.
And so this amendment protects something that you think should remain in the Constitution?
I was asked to bring this by the ports in my district, and I'm sure it affects the ports around the state.
And so you're just following the guidance that we received to protect things in the Constitution with amendments? That's what you're doing here? Thank you.
That would be correct.
Representative Phelps has offered up an amendment. Is there any objections to the adoption of the amendment? Rep. Boyer, on your objection?
Members, I think our ports are important to us. I have a port in my district, and but for the same reason as noted before, we're trying to build this bill in an effort to get some support. And if we're adding amendments that you all are not supporting, and it's no point in adding the amendments, so I'm going to object.
Rep. Phelps, you have a right to close on your amendment. You waive? Okay, members, Representative Phelps has offered up an amendment which Rep. Boyer has objected to. All those in favor of the amendment vote yea. All those opposed vote nay. Madam Clerk, please open the machines. Members, vote your machines. Members, vote your machines. Hilferty, nay. Emerson, nay. Orgeron, nay. Boyer, no. Glorioso, no. Gadberry, no. Members are either voting. The clerk will close the machine. We have 31 yeas, 70 nays, and the amendment fails. Next amendment.
Representative Miller offers up set number 4271.
Rep. Miller on your amendment.
Members, we have the nation's only historically black college and university system. It's in its 143rd year of its existence. It's a diverse mixture of campuses in Baton Rouge, New Orleans, Shreveport, as well as a law center and ag research and extension center. Members of my district have asked me to bring this amendment because it's important to them. I ask that you support it.
Representative Wright, you had your button pressed, Rep. Wright. I know you're in a conversation. Representative Wright, you had the question on the amendment? He waives, okay. Any objections to the adoption of the amendment? Hearing no objections, the amendment is adopted. Next amendment.
Representative Bagley offers up set number 4194.
Rep. Bagley on your amendment.
Thank you, members. Thank you, Mr. Speaker. As others, I come to bring amendments to try to cure problems I have at home. I've gotten, I don't know about you, but I've probably got 500 or 600 texts and emails about all this. I haven't, and they all have the same question: why are we, why can't we fix this? So in answer to that, I'm going to try to do that. And my amendment will put between lines 14 and 15 on page 4 of the bill 800 to include Article 7, Section 9, and Article 10, Section 29. Section 9 is the state employment or retirement for state employees, which everybody sitting around here would probably agree with this, and most everybody behind you. On Article 10, Section 29, that's public school retirement. So those are the two would be included in this if you pass it.
Rep. Thomas, why do you rise?
I'm looking at the board that says 4194, and when I look at my computer with 4194, it is not what Representative Bagley's talking about.
And you were probably the best student all throughout school.
I
Rep. Bagley,
apologize.
can we get on the right amendment?
I thought we were going to do that. Excuse me. All right,
Okay.
so let's get back on the right one. This one would be on page 4, between line 14 and 15, to include Article 5, Section 23. This is the retirement for judges. The judges in my area had called me and wanted to see if I would do that. I said I would, so it would just be sure that their judges' retirement would not be bothered with. Questions?
Rep. Wright for a question on the amendment.
Thank you, Mr. Speaker. Representative Bagley, I was, just out of fairness, I know some people don't like me asking this question, but you're bringing this amendment. Are you prepared to vote for the bill, support the?
Representative, I've got 2 bills. I'll do the next one next. And yes, if I pass these 2 bills, I will vote for.
So let me ask you this. I was trying to bring this out last couple of amendments. People are using the term protect, right? Protect this part of the Constitution or whatever, some specific issue. Can you help me or enlighten me on the idea of protecting pensions? I've not heard anybody talk about pensions, but obviously you said somebody asked you to do this. Let's talk about that.
Well, I know there are a lot of people in here that get pension. I do. There are people, again, behind you, to the right and the left of you, behind this. Pension are basically what we live on once we are too old to get a job. Rather than not having a job and having people take care of us, that's what we work our entire life to do. And there were 2 groups that regularly send emails to me since this came up to protect their retirement, and that's what my 2 amendments are going to do.
No, understood. Do you think that there's any possibility that the people in this convention, elected officials here across the hall and other, would want to rate a pension through the Constitutional Convention?
Their fear and my fear is that out of trying to make things better would change things that would possibly hurt a group or individuals or whatever. I'd like to see it stay just like it is. We know what it is. If there's needs to be changed, we still can change it by 2/3 of the body if we have a particular deal. So I just ask the members to support me in both these amendments, especially this first one. Thank you, Mr.
Appreciate it.
Rep. Glorioso for a question on the amendment.
Representative Bagley.
Yes.
Article 5, Section 23 has an A and a B. And the A section is, I believe, what you're talking about, which is where the retirement system is created.
Yes, sir.
The B section is the mandatory retirement age.
It was not, my amendment wouldn't, well,
It would, the way it's
Yeah,
worded.
it
So my
actually
question
would've.
is, would you limit your amendment to Article 5, Section 23A, so that we have the option to address, if we choose to, the mandatory retirement age?
I would entertain that, yes, sir.
Okay, thank you.
Representative Bagley has offered up an amendment. Are any objections to the adoption of the amendment? Hearing no objections, the amendment is adopted. Next amendment, Madam Clerk. Yeah, but they can work through the process. Let's go to the next.
Next set of amendments offered by Representative Bagley, set number 4192.
Rep. Glorioso, can you come see? Rep. Bagley on your amendment.
Thank you, Mr. Speaker. And Representative Thomas, we'll get back on the right deal now. The second one amendment is to include Article 7, Section 9, that's the state retirement, and Article 10, Section 29, that's the public school retirement. I'd like to add both of those in between lines 14 and 15 of House Bill 800. If you have a question, I'll have an answer.
Rep. Wright for a question on the amendment.
Thank you, Mr. Speaker. Representative Bagley, I appreciate the last conversation. Just want to talk about this amendment here. I know we're trying to protect something here. Can you tell us about that? And does that mean you're going to vote for the bill?
Well, yes, if this passes, we already got half of it done, certainly. I told you originally I am. School retirement, big for me. I'm a retired school teacher. I get a lot of mail about school things, and this one is one. Has been probably the biggest one I get is about school retirees. They're afraid that something may happen to the way they figure school retirement, the percentages, that sort of thing. And so I'd like to keep, again, if there's something that we need changed, we can still go back under the new Constitution or the revised Constitution and change it then. Right now, I don't think there's anybody that has a taste for that.
Understood. All right, thank you for answering.
Thank you, Representative.
Rep. Mandy Landry for a question on the amendment.
Yeah, Rep. Bagley, I think you said your amendments come from constituents, is that right?
Yes.
Or concerns. And also, I've heard, for instance, the sheriffs are concerned and the DAs are concerned and all these different groups. And to me, the point of your amendments and judges and others is that there are people out there who are really worried they're going to be kicked to the curb. I mean, is that part of the concern with these amendments?
No, ma'am. In fact, I had
No?
I had 4 amendments originally. 2 others were placed in before mine, and so those 2 I let go. The 4 things that I hear in my office, and these were 2 of the 4, and I thought they were important enough to try to bring amendments to. I found out again that there were others that had already done the same thing, and so I relented to them to let them bring that
Okay,
bill.
I think I stated my question wrong, but a lot of these amendments, or most of them, even the one that was adopted, the intent is to, I know someone didn't like the word protect, but to protect, to make sure that certain groups, judges, whatever, are not touched. So if that's what we're doing, isn't that kind of proving the point that there are a lot of people out there that are really concerned about what might happen?
Well, I don't think there's any question there people are concerned. And again, I get a lot of mail and a lot of calls and a lot of texts.
Same.
Sitting there today, during this, wanting me to vote certain ways and do certain things. And, we all do what the best we think, or I do, the best I think I can do for my constituents. I think everybody in this building feels that way. So these were some ways I could help, things that people ask me. And obviously being a teacher, and I have spoken to many of the teachers groups, and when they have teacher problems, they call me or text me, and that was certainly a major one.
And they're very concerned, as they should be, because they don't have as much of a voice up here. And this will be a question, I promise. I think someone else, I think it was Rep. Willard, talked about.
All you have to do is say, did you know?
Or Jason. No, it's a kind of a follow-up that they said, well, we can do this almost section by section, issue by issue, but it seems that people in charge don't want to do that. They just want to up or down vote on the whole thing. You're right, that is more of a did you know. But I appreciate you bringing this on behalf of teachers. There's a lot of people protected in the Constitution, and they are because voters like us chose to do that. Thank you.
Thank you, Representative Landry.
Rep McCormick for the floor on the amendment.
Thank you, Mr. Speaker. I'm not rising to particularly object to this bill or to oppose this, this amendment. But you know, we've been sitting here for hours talking about how people were protected in the state. We're talking about government employees, period. We don't give any thought, it seems like, to the rest of society. The ones that labor, where I come from, 10 or 12 hours a day, 6 or 7 days a week. We don't even consider them. Here in about a year, what we're going to do is we're going to protect everything and everybody. And then those guys back home that are in the ditch working every day, we're going to raise taxes on them so we can keep doing what we're doing. You know, we talk about deep cuts to health care and higher ed. I'm not here to protect health care and higher ed. I'm here to protect the working class people of this state and the small business owners that are seen as serfs in this state for too many years. We get up here and we honor people every day. We honor really good people, good groups of people. But I want to read to you the 10 most deadliest jobs.
Rep McCormick, I would ask if you could come to the floor on the bill instead of on the amendment. That's okay. Unless you want to.
I think it applies to the.
If it applies to the amendment, go ahead as you are.
And just one, if you engage me just one quick second. The 10 most deadliest jobs in Louisiana, most likely to not come home from work per capita. The people we never talk about in this building: construction workers, farmers and ranchers, oil and gas extractors, truck drivers, electrical power line and installation repairers, garbage collectors, roofers, aircraft pilots, fishermen. Jack, you know what the most dangerous job is by far? Log work, people that work in the logging industry. When we're going ahead and we're trying to protect all these different groups of people, let's don't forget the main group, the hardworking people of the state. Thank you, Mr. Speaker. Thank you.
Rep McCormick, will you take a question on your floor? Rep Willard?
Sure, go ahead.
Thank you, Mr. Speaker. Rep McCormick, you piqued my interest. Do you have any ideas on how we could protect those groups that you just referenced?
Yes, we could have this constitutional convention. We could put everything on the table and see what we need to do to lower taxes and lower regulations on these people. There's no country in history ever taxed themselves into prosperity, so that's what we can do.
So you're opposed to a limited constitutional convention?
You'd have to define limited.
What is being proposed right now? Because you said you want to open it up to address everything.
I'm for leaving our basic rights in there, yes. I think that's what this limited constitution does. It only takes out, I believe what it's going to do, it's going to take out the fiscal concerns we have when it comes to balancing our budget.
Okay. And as it relates to the amendment proposed by Rep. Bagley, did you rise in opposition to that, in support of it?
I'm going to follow the chairman's lead on this. I think we've put too many amendments on it. If he doesn't oppose it, I'm not going to oppose it.
Gotcha. Thank you.
Thank you.
Okay, members, Representative Bagley has offered up an amendment. Any objections to the adoption of the amendment? Hearing no objections, the amendment is adopted. Next amendment.
Representative Fontenot offers up set number 4263.
Rep. Fontenot on your amendment.
Thank you, Mr. Speaker. Members, there's 4 amendments that would remove the ability for it to be discussed into the Constitutional Convention. The first is Article 5, Section 26, as it pertains to district attorneys and the qualifications of district attorneys. Article 5, Section 27, as it pertains to the sheriffs and the authority of sheriffs to preserve the office of the sheriffs at its current authority. Article 7, Section 3, would ensure and preserve the role of local governments to collect sales taxes. And the last one pertains to police and fire state supplemental pay to ensure that those individuals would continue to receive those benefits by this state.
Rep. Wright for a question on the amendment.
Thank you, Mr. Speaker. Representative Fontenot, good to see you. As discussed with previous reps and coming back again, I know you took issue, I mean, not issue, I know you're drafting some amendments with this. Can you tell me a little bit about how you feel you're going to vote on this bill after the amendments?
Well, I've heard you ask that to everybody, and so let me say this, that this is something that's probably been in the works for as long as I considered politics. For the last 10 years, this body couldn't make this lift. And contrary to what I see on the news and these false advertisements about we're just going to upend the Constitution, is truly false. I spent some time to read the Constitution and read the bill and understand that we're just giving this body the power to fix the things that may have hampered us over the years. So the question to your answer is, if these amendments wouldn't get on, I still would vote for this because it's right for the people of this state. But more importantly, if this was to get into statute, there would never be 70 votes in this body to take away the authority of the district attorney, the authority of the sheriff, or state and police supplemental pay. I'm doing this to ease them, to ensure that. But this body has the voice of the people, and it's time we make this step, whether this is there or not. I'm going to stand with the governor, the speaker, and Representative Bouye to make this change for Louisiana.
Appreciate your answer. Thank you, Rep.
Rep. Willard for a question on the amendment.
Thank you, Mr. Speaker. Rep. Fontenot, you just said that you think that this is the right thing to do for the people of Louisiana. Do you have any evidence or proof that the people of Louisiana believe we need to go into a constitutional convention?
Well, whether they believe that or not, it's our job to make that decision. But let me say this, Rep. There has never been one time that your side of the aisle has proposed a constitutional amendment, and I voted no. I believe that any opportunity that we can give the people of this state to have a voice and say yes or no, that's our duty. And this is what this opportunity is for us. It's for us to either, whether you agree or disagree, when this is over, Representative Willard, you may go out and tell the people to vote no. But the people will speak. When the final product is delivered to the people, and all we're doing is putting it in statute, it will be those people of this state, the electors, to decide if it's the right path. So what I'm doing today and what you're doing today is to move this bill to the Senate to give the people the opportunity to examine where we are fiscally on all of these issues.
Okay, I just wanted to know if you were privy to some kind of information or polling that I had not seen showing that the people of Louisiana supported the Constitutional Convention.
I think the people will speak.
So my question, I know you said your amendments deal with DAs, sheriffs, and the ability of locals to collect sales taxes. Is
That is correct.
Does it do anything related to the inventory tax?
No, sir.
Okay, thank you.
Thank you.
Rep. Mandy Landry for a question on the amendment.
Rev. Fontenot, is it the sheriffs and DAs themselves who are concerned about how they might be treated, or is that just like a general concern?
I don't necessarily know. This is strictly about the ability, the authority. So I think that is their concern. I don't think how they can be treated, but there's.
Well, how they'll be addressed.
Yeah, I could agree to that. Yes, ma'am.
Okay, so saying something out loud, everyone knows the sheriffs and the DAs are very politically popular. So even people, powerful, I don't know if they're popular, even people who are, or groups that are very politically powerful are concerned about this convention. I mean, that's what it seems like from you being requested to handle this. Yes? No?
I could agree with you. Yes.
You can agree with that? Okay, thank you.
Okay, members, Representative Fontenot has offered up an amendment. Any objections to the adoption of the amendment? Hearing no objections, the amendment is adopted. Next, Madam Clerk.
Representative Boyd offers up four page amendments, 4284.
There you go. Yeah, because everyone's afraid. Powerful.
I'm not real sure what happened. Rep. Boyd, on your amendment.
Thank you, Mr. Speaker. Good afternoon, members. I think we all can agree that the Constitution should be updated, some changes made to it. I think where the division comes is the timing on it. I've heard several people today talk about the timing. My amendment is to change the bill into a study that would do the road shows like that were done for the redistricting. We would then convene and January of 2026. The delegates will be elected this year in November. That way we get the input from our constituents, from people around the state on what they deem should be changed and could be changed for the better, and have the election in 2026. Thank you.
Rep. Cruz for a question on the amendment.
Representative Boyd, just to make sure I understand this, your amendment would actually change the bill to a...
Rep. Cruz, she waives on the questions. So Representative Boyd has offered up a set of amendments. Is there any objections to the adoption of the amendment? Rep. Boyer?
Thank you, Mr. Speaker. Members, I again rise to object. This is, if Representative Boyd would have wanted to bring this study resolution, she would have been able to do that during our normal proceedings by filing a bill and having it heard. This bill is not that instrument. This completely changes the whole point of us going into the convention at this time. So I object.
Rep. Boyd, you have a right to close.
Rep. White, I would vote for this if it got on, and I ask for your favorable passage.
All right, members, Representative Boyd has offered up a set of amendments, which Representative Boyer has objected to. All those in favor of the amendment vote yea. All those opposed vote nay. Madam Clerk, please open machines. Boyer, no. Members, vote your machines. Members, vote your machine. Mack, no. Members, vote your machines. Schlegel, no. The clerk will close the machine. Thompson, no. Schlegel's a no. Okay, Schlegel's a no. The clerk will close the machine. We have 29 yeas, 73 nays, and the amendment fails. Next amendment.
Representative Ogeron offers up set number 4286.
Rep. Orgeron on your amendment.
Thank you very much, Mr. Speaker. All the amendment that I was proposing would be taking the full assembly that we have right now scheduled from August 1st through August 15th, which is actually spanning over 3 work weeks and 2 weekends, and it would basically just change it to be 2 work weeks, Monday through Friday, the 5th through the 16th. After consulting with the chairman, he asked me to withdraw it, which I agreed that he would, saying that it's very likely, or it will be taken care of at a subsequent point in time in order to do that. So with that, I'd like to withdraw the amendment.
Without objection.
I gave him my word.
Right, Rep. Jordan for the floor on the bill.
Thank you, Mr. Speaker and members. I rise in opposition to this bill, and so let me give you a few reasons why. I understand that all these amendments have just been passed, and I hope it makes the sheriffs feel good and the teachers and the retirement system. I hope it makes all of them feel good. But the truth of the matter is, none of these amendments really mean anything once we go into a convention. Once we go into a convention, the enabling legislation really means nothing. The rules of the convention are what dictate. And so, from that perspective, while I understand and I fully trust the author, the governor, and others who have made statements that they want to limit the convention, it doesn't do that. It says that they're not going to touch Articles 1 through 4. But once we get into a convention, it doesn't really mean anything. If somebody wants to bring something that affects Article 1, there's really no issue of germaneness. But if we really wanted to limit it, there is a better way to do this. And the way to do it would be to call a special session dedicated to the Constitution, whether it's just Articles 6 and 7, or you could have all 14 articles. and you could do a rewrite of the Constitution, if that's really what you wanted to do within those articles. And if you did that, we would have a few protections. If we went outside of the call, we could have an issue of germaneness, and we could stop it right here within the session. It also would take 2/3 vote of the body to take something out of the Constitution. If it takes 2/3 vote to put it in and 50% of the voters to do it, it should also take 2/3 vote of the legislature and a majority of the public to take it out. And so if we wanted to do that, that is a simpler and a better way to do it. I heard one of the first things that Rep. Boyer said when he came to the mic. He said, these are the things that we would like to be protected. He can't guarantee that they would be protected because the law doesn't allow for that. The Constitution does not allow for that. And I know they talked about legislative intent. If we're talking about legislative intent, we already passed the point. We only get to court and talk about legislative intent once somebody has done something outside of the scope of the convention, it's been placed on the ballot, and now we have to go to court to try to challenge it. So that's after the fact. And so for all those reasons, I would tell you that this is not a good idea. To me, the special session is better. Now, let's talk about if we go into a special session, maybe we don't have the delegates. Well, the governor could take the delegates, and he could use them as a task force or as a sounding board, and they could go through the Constitution and figure out what they want to change. Those things could become part of the call. And so they would have some influence and some input. They would have a seat at the table because they would help define what the call is. And that call, again, helps limit what we could vote on. So we'd have the limitations in place as opposed to these amendments, which mean very little. We would have a call which really defines limits. We would have the 2/3 protection that we use to put things into the Constitution. Those things would still have the same measure to take it out. And we would have the issue of germaneness, and we wouldn't have all these questions of how this is going to operate. I think Rep. Hughes and Rep. Willett proposed questions as to how this was going to operate. There were a lot of, well, I'm not exactly sure. This is what we propose, some of those things. We know how a special session works. We know this. We're familiar with this. We know the role that the clerk would have. We know the role that the speaker would have. We know the role that the Senate president and the Senate would have. We know how all these things work. But even with the special session, I would tell you, part of this still is an issue of timing. We really haven't had the public input. And I do think that we need the public's input for some of these things. If you believe in polls, not telling you I always believe in them, but if you believe in polls, the recent poll that came out shows that only 1% of Louisiana's population believe that this is a top priority. And of those who took an issue on the poll, on the Constitution, 29% were for, were against the Constitutional Convention, 27% were for, and I guess the other 44% really didn't even matter to them one way or the other. So this is not really a top priority. But I would think that if we did a road show, we took a year to talk to the public, maybe those numbers go up. Maybe we are able to inform them about why this might be important. The other issue is we've got 14 articles in the Constitution. We've got things like trust funds that may come out. Maybe they're no longer relevant. I don't know. But are you at least curious as to why they were put in the Constitution in the first place? I think we owe it to our constituents to have a little bit of intellectual curiosity to say, hey, look, maybe these things have outlived their usefulness, but maybe they haven't. Let's get into the background of why they were there to begin with. And maybe once we answer those questions, that helps. I don't know that we can correct in 14 days what it took 14 months to do. You know, I like a delicious meal, but at least I want to know what's on the menu. And right now, I don't know if any of us actually know what's on the menu. We don't know what we're really ordering. And so I would ask you to take that into consideration as you make your vote. And if you decide to vote for it, we all have the right to vote for or against. But you should at least be able to go back to your constituents, to the people who voted for you, and tell them exactly what you voted on. And at this point, I don't think we have those answers other than we'll figure it out once we get to the convention. So for all those reasons, I rise in opposition to HB 800.
Rep. Jordan, will you take a question?
Absolutely.
Rep. Fontenot for a question.
Thank you, Mr. Speaker. Rep. Jordan, I always appreciate your comments, but I want to go to, you said that passing these amendments would have no effect, that if we went into a constitution convention, that all things would be open. So my question to you is, Rep. Bouye has said that we would come in and the first thing we would do would be establish the rules. I'm under the belief by passing these amendments that the rules that we, all the delegates will vote on, will limit what's debatable. Do you disagree to that?
I do absolutely disagree with that because the Constitution doesn't call for a limited convention. And so the only way, once you go into a constitutional convention, everything is open. And so from a legal perspective, it is my opinion that once you go into a constitutional convention, everything is on the table.
I want to go to, you said that it take 2/3 vote to put something in the Constitution. Would you not agree that the proposed here would be to move these constitutional amendments into statute, which would then subsequently require 2/3 vote of both of the House and the Senate to change?
No, not exactly, because let me tell you when we talk about that. So when I say it takes 2/3 votes for us to put something on the ballot, it takes 2/3 of this body. You need 70 votes here, 26 on the other side, 50% of the people to do that. Now, we get into the convention, it only takes 50% of the House, 50% of the Senate, 50% of the delegates, and then it goes to the body, to the people for 50%. Now, if we went into the special session, it would take those 2/3 vote of the House, 2/3 vote of the Senate, 50% of the body to take, of the public to take those things out. So to me, that is a better way and a more secure way of doing it, and frankly, a fair way, since the same way we put it in would be the same way we're taking it out.
I respect that, Rep. Jordan, but you give me an attorney conflicting argument. What you're talking about is adding something into the Constitution and subsequently changing. But in this particular instance, we're not changing anything. We're just moving it into statute. And once it gets into statute...
Let me correct that. You can't say that. The intent is not to change anything. But once you go in, you can't definitively say we're not changing anything. And I think that's the fundamental disagreement and the issue that we have. When we make definitive statements like we're not doing this, that's not true. The intent is for us not to do this, but that doesn't mean that that's actually what we're going to do.
So you believe the confines of this bill, once passed, will have no bearing once we enter into a convention?
Based on my legal interpretation of it, based on the people that were part of the 73 convention, and based on the people who have institutional knowledge of how this legislature works, yeah, I firmly believe that that's the case.
And I want to go to the people, because you said a lot about the people's input. Between now and whenever this is going to be on the ballot, you don't believe the people will have input, that you'll have town hall meetings, we'll address the people's concerns, or when we hear in August that they'll come here and give us their concerns? There could be some items that may never come out,
Well,
correct?
let me say it to you like this. Again, I don't think, last time it took 13, 14 months. We're trying to do this in 13, 14 days. Let's assume that we go by this timeline. Now, by this timeline, we'll have this thing done by August 20th. So we'll have that final product that Rep. Bouye talked about. So we're talking about a November election. So, but you might as well say September 1st. So you're talking about September and October and half of November. So you got 2.5 months to try to educate people of what is on here. Now, I don't think, from my perspective, I don't think that's enough time. I don't think that gives us enough time to get public input. But even once you get the input, what is it worth? Because all you're really doing is educating them. You can't go back and change anything because now it's on the ballot. I would suggest to you it would be better for us to get the input, take some time, get the input from the people before we go and mess with the Constitution to put something on the ballot. So, look, I mean, if you disagree with that process, then we just have a fundamental disagreement. But I would like to get the input on the front end rather than, because I don't even call it input on the back end because it's just education, because no matter what they say, it has no bearing or control because it's already been passed and on the ballot now.
When you speak to people, I have two constituents that were delegates in 1973 on the convention. Have you ever spoken to those people and what they think, what the Constitution would look like
I have.
some 40 years later?
I've spoken to some people that were involved with it.
And I want to finish with this because you talked about only 1%. You believe that the...
Going by the poll. I told you, that's whether you believe the poll or not now. That's what the poll states.
Neither here nor there. I don't believe there's a lot of misinformation, misconceptions that we're going to just do what we done in 1973. We're really not. 1973 rewrote the entire Constitution. All we're doing is taking things and putting them in a statute so you as an elected official in 25 can make a decision.
Again, let me correct you. Our intent is just to do that. I don't think that that's what that does, but look, I'm just telling you from what I understand, and I appreciate it as a legal perspective, I understand what our intent is, and I'm not trying to say that what we intend to do ultimately may not be what we do. What I'm telling you is I don't have a comfort level with that because I know that the Constitution doesn't call for a limited convention, and so everything is on the table whether we intend it or not.
I appreciate it. Thank you, Mr. Speaker.
Rep. Hughes for a question.
Thank you, Mr. Speaker. Representative Jordan, I'm not an attorney, so hopefully you can clarify just a couple things for me and my constituents. If we establish a set of rules, could the rules be suspended at any time per Robert's Rules of Order by a vote of the delegates?
I think absolutely it could be, but even before that, we don't have to establish rules based on the enabling legislation.
Let me ask another question pertaining to the rules. We established this and passed this enabling legislation, and a delegate decides that they want to touch something that is prohibited by the enabling legislation or the rules, and the presiding officer rules that that motion is out of order. Could a delegate move to override the chair?
Absolutely.
Representative Jordan, in legal spheres, I often hear the term precedent. Has a precedent been set from the 1973 Constitutional Convention?
It has.
Where the delegates of that convention ignored the enabling legislation and did what they wanted to do?
It has been and could be repeated.
Thank you, Mr. Speaker.
Okay, the member's out of time. Is there an objection to granting an additional 1 minute? Hearing no objections, you have another minute. Representative Mandy Landry for a question.
Make it quick, Mandy. We got a minute.
I got a minute. I already sort of asked this. So you've been here longer than me. The sheriffs and the DAs are kingmakers. So if they're concerned about this, shouldn't we all be concerned about this?
Absolutely, and let me tell you this. I mean, we did an amendment, whether it touches supplemental pay or what have you. I know that's the intent, but if somebody wants to come back and say that, you know what, we want to take away supplemental pay from the sheriffs, they could do that. If they could get a majority of those 3 chambers for the convention, it would be on the ballot.
I've been calling this a pinky promise. I think you probably agree.
I agree.
Thanks.
20 seconds left. Rep. Willard for a question.
Thank you, Mr. Speaker. Rep. Jordan, do you think that if this bill passes and we go into a convention, that it's possible for something to be removed from the Constitution and not placed in the statute?
Could be possible for it to remove, but it could also be possible that things could be added as well.
Thank you.
Rep. Wilford Carter for the floor.
Thank you, Mr. Speaker.
Thank you, Mr. Speaker, members. This Constitution we have is about 79,000 words. It's one of the longest constitutions in the country. I think top 3. And no one disagreed that some stuff in it ought to come out. Problem we have is this legislation is, number one, it's being orchestrated by special interests under the disguise of a people's document. So normally we would have delegates elected from the people whose job it is to do this Constitution, to rewrite this Constitution. They're not special interest people. They are people that wants to run to be delegates of the Constitution from all and any walk of life. They're not legislators that have political alignments necessarily, okay? So for the second time in history, we asking the legislators and a few good folks appointed by the governor to write our Constitution. Legislators, of a third of which is the first time coming here and has another election to run. Another third, have at least one more election to run. So they preoccupy with raising funds for the election. They preoccupy with getting reelected. They preoccupy with serving their political agenda. That's the biggest problem I have with this Constitutional Amendment. So there are several specific things that we're going to run into, the reason why I rise against it. It's no secret I'm against the Constitutional Amendment as it's presently presented to us, because it's talking about 2 weeks, sometime from May 30 to June 3rd or 4th or whenever, we're going to have hearings for the people. Hearings on the present Constitution. That's 79,000 words. That has 14 articles. And most articles, many of them have 25 to 30 some odd sections. Okay? We're going to let the people come here about what they think they ought to stay in the Constitution. Then we're going to take a break and have folks come and comment some more. And then we're going to write up a Constitution by August 15 for certain. So the people don't get a chance to see the finished product until August 15th. They can't come back and say, I don't like this and I don't like that. They stuck. They either have to vote it up or vote it down after August 15. That's what I don't like. It's taking politicians in order to write up a Constitution. Okay, that's what we're doing. Not the people whose primary focus is on the Constitution. We have other focus. We may be good, can do many things at the same time, but we do all have political interests and we have political ambitions. So you think that because we put these amendments in the Constitution, that these things are protected. I agree. Unless you have an enabling legislation passed at the same time this constitutional amendment is presented to the people, like they did in '93, that that the legislature can have a partial constitutional convention with certain limitations. I see the only way that you can have that done, like they did in '93. So this legislation does not have language in it to authorize the legislature to have a partial convention. So if that's not in there, it's become questionable whether all of these exceptions that we're not going to touch is going to be able to be protected. Okay? Next problem I have. We have a society of electorate that's made up of 32% Republican, about 34% Democrat, and about 30% independent, no party. There's no party independent in the House. I don't think there's any in the Senate. There may be some in the governor's appointment, but they're not going to have any input until this is over with. Don't think it's fair. I think it violates the 14th Amendment, equal protection law. You're going to write up a constitution that's going to impact folks for the next 70, probably 70 years, 4 generations, 3 or 4 generations. And a large segment of people not going to have input. I think you're asking for trouble, and this convention going to pretty much come out the same way this legislature come out, because it's made up of 73 Republicans and 32 Democrats. Yes, the Democrats get a voice, not much of a voice. We all know how this is going to go. I make these statements because I make a record, because this is a challenging situation. And if you wanted to do the right thing, you would give opportunity for the people to come and write this Constitution, not the politician, okay? You would at least give a chance for the people to comment on your finished product before they have to vote on it, to actually have opportunity to comment and make changes in what you propose. When we function here in the legislature, the bill is introduced, that bill is well known to the public, it's publicized, the people come up and comment about that bill, whether it's bad or good. We're not doing this in this Constitution. Don't think we're doing this. We're going to have a finished product by August 15. They can comment on the present Constitution, what changes they like to make or don't want to make. But when we finish that product August 15, they're not going to get a chance to say that they got a problem with this, they got a problem with that. And I believe, lastly, the reason why I'm against this process, this convention, because I believe the Constitution is being written as we speak. It's already started. The reason why I believe that is because there's no way you can write a Constitution of 14 articles involving some 32 sections or take those out in 2 weeks. You can't do it in 2 weeks, you can't do it in 3 weeks, you can't do it in 3 months. So somebody's starting from something already. And by the fact that they didn't want my amendments to protect the judges, they already got a plan about the Article 5. Whose plan is this? It's not the people's plan. It may be the Republicans in the House plan. Maybe y'all got together and come up with a plan. I don't think it's your plan either. You're going along with the process, though. For whatever reason, you're going along with it. But I want to tell you, it's not something the people of this state want, this process that we're having. And we're setting a bad precedent. I was not here in 93 when we tried something similar for different reasons. If folks already know who's writing this Constitution or have the ideas of how they're doing this, the Governor's Transition Committee, the Pelican Institute, Lobby, they're already writing this stuff up. If they don't have it written up, why would they say executive privilege? I'm not going to provide information because of executive privilege or because of legislative privilege. Okay? You folks may not know what's going on, but somebody do. And I think it ought to be the people, not the people that's trying to force themselves and their will and their interest onto all of us. And that's why I asked to vote against this bill.
Rep. Newell for the floor.
Thank you, Mr. Speaker and members. First of all, I do want to tell Chairman Boyer, I do want to thank Chairman Boyer for his time and the fact that he did give us 3 days to discuss this bill in committee. But what was a constant comment in committee was the time and the education portion of this process. I don't have an opposition to having a constitutional convention. I was on the Constitutional Convention Task Force last term. I'm very interested in the four corners of what guides our state. But what my concern is the lack of public input and the lack of time that we as legislators who are going to be forced into this process would have to have deliberate conversations and an actual opportunity to digest and understand what is being changed and how those changes will affect the way we continue to govern our state. And we keep speaking about the 1973 Constitutional Convention. It took those delegates 3 months to come up with the rules in which they would govern themselves by. And they wrote their own rules. We were speaking about how this is going to go. The delegates in 1973, like I said, they wrote their own rules. Our legislation would provide that our already overworked yet awesome staff would have to provide staffing to this. We just changed the rules to have a 72-hour turnaround for bill proposals. We have a 24-hour turnaround for amendments to be presented to committees. What is that process going to look like? And how much overtime and how much extra work are we expecting from our staff? Rep. Jordan made the comment that we know what our intent is, but we know what our intent is. We have not spoken to those 27 delegates that I believe will have a greater voice than the people who were elected to this body. I did not ask to be elected to be a delegate to a constitutional convention, but I did get elected to represent the people of District 99. But I do not believe that the people of District 99 will have the voice and the representation that they need, because I think that our votes in this House and in the Senate will be overshadowed, or there will be too much influence over our votes and voice by outside interest groups, whether it's those 27 delegates, whether it's some of the visitors that we have today. I don't believe that everyone is going to be acting in their own accord. If we went back to the process we had last time, voting in our delegates, letting the governor pick his 27, this would be a much better process, and a process that we all could be comfortable with. And I'm also concerned about the constitutionality of the final product, because right now, as I'm reading decisions and what's going through, I don't think these bodies have been formed constitutionally this term. So I have a lot of questions, and I have a lot of concerns with this. Do I think we should have a constitutional convention? Yes. Do I think it should be in 3 weeks? Absolutely not. Thank you, Mr. Speaker and members.
Rep. Mandy Landry for the floor.
So following up on what I said and a couple others, this is completely political. This is just like the crime session. Very few Republicans even bothered to ask questions. The crime session, no one was paying attention. People were talking so loud we couldn't hear. Everyone knows what's going to happen. And some people were objecting to giving people more time. We are about to change our laws for the first time in half a century, and people don't even want to listen to this. And it's because they know what's going to happen, at least in this body. You have here just now the DAs and the sheriffs. No one has more power than them in government. There's outside groups. No one has more power than them, and they think that they're going to be messed with, because they might, because everything can happen when we go in there. 27 delegates appointed by one person, many of them extraordinarily rich men. Why do they have to be there? People have said, oh, it's because we had 27 delegates appointed by the governor in 74 or 73. Well, why don't we take the same amount of time as they had in 73? There's nothing preventing us from doing that. I have a lot of issues with the fact that it's just a bunch of rich men who are doing this and pushing this. This body is very wealthy compared to the rest of the state. You have no one in here who is working class. There's not many of us who actually have to work for a living. That's just how it is in here. So you're going to have people who aren't very understanding of what the poor people we represent go through, and then you have people coming in who are multimillionaires, if not more than that.
Rep. Mandy, if you can stay on the bill, please.
Well, the bill is, are we going to do this?
Talking about members' wealth. I'm asking
about
you to
what?
stay on the bill.
Okay. Anyway, as Rep. Jordan said, there's been a lot of polling. Some of it actually said that a majority of people approve of the governor, and 1% only approve of doing this convention. And we're not listening to the people who elected us. I've heard from innumerable people that there are drafts out there. I really would like to see them. And the point being, why are we doing this now? We've already showed that people are willing to change the time on this, that it was supposed to be during session, supposed to be right after session, and now we're doing it in August. And to me, that shows this time frame can be changed. It really can be. We can follow what happened in 73. We can elect delegates. It might not be us. I don't know if I would want to come back for a whole year. I have to pay my mortgage, which has almost doubled because of homeowners insurance. We have a lot of stuff to do that is that important, and to say we have to do this now, it just falls flat. I mean, why not last time? It's because of the governor we had. Why not the time before? See, you can't even hear. Anyway, we know it's going to happen here, but I just hope some of y'all think about the questions we ask and some of the comments we made, and you can't really deny most of the things we said. So hopefully, as Judge said, we're making our record for what happens, what will undoubtedly happen later on. Thanks, Judge.
Will you take any questions?
Sure.
Rep. Bayham for a question.
Representative Landry, you said that we're a bunch of wealthy people. Do you realize I drive a 2007 Toyota pickup truck?
Okay, so I wasn't talking about you specifically. This body is
I
overall
left the rules in
wealthy.
Chalmette on my way here.
Yeah, I can't
Had to
afford my
take the
mortgage
truck.
right now, so I understand that. Overall, this body is wealthier than the people who live in this state.
Representative Wright for the floor on the bill.
Thank you, Mr. Speaker. Colleagues, just couldn't resist coming to the floor and talking about this. I've shared with members of our delegation that I think this is the most important thing that we could do in my legislative career, in this term, in this year, in this session, and you know, I just got to share a little bit about it, quite frankly. My favorite founding father, member of the original, convention for the U.S. Federal Convention, is James Madison. They call him the father of the Constitution. He's a really interesting person if you've ever taken some time to listen or read about his history, and clearly we've got stories about our founding fathers that make them out to be saints, some not so much, but I have found him to be the most prudent, the most amazing of the founders intellectually. And what was really interesting in reading about him was that he clearly was the leader and the shaper of the constitutional conventions, but he didn't get mostly anything that he really wanted. He had some pretty strong ideas. He crafted some of the compromises and things like that, but he walked away not getting the things that he thought were needed for a constitution. And I think that's pretty amazing, especially when you compare it to what we're talking about now. I think I'm getting older and wiser enough to know the timing's never the way you want it. You never get it the way you want it. And maybe there's some parts of this that aren't ideal. Maybe there's some parts of this that aren't the way I envisioned it. But it's an opportunity. And I would argue it's the last opportunity we'll see in this term, perhaps beyond. When I ran for state representative, it was in 2017. It was a special election. I had been involved in politics in a variety of ways for a number of years, enjoyed thinking, talking, debating policy. But it wasn't until those couple of years leading up to that election, and that was 15, 16, 17, when it became obvious, when we started seeing the deficits, when it started seeing what our budgets became and how little we had an ability to have an effect on. Some people have suggested that the legislature, the government, is on autopilot, and that's pretty close to it in many ways. A very small percentage, and we saw that. I walked around, went to campaign things, and I got it on some mailers. I wanted to change the Constitution. So that's 8 years ago. And I brought a few bills. I'll tell you about that in a second. But I know I wasn't like the first. I'm not bragging. I mean, it was I mean, that was 8 years ago, and God knows it was before. I bragged to a couple of Republicans in St. Tammany that I thought Neil Abramson was the coolest rep. I wanted to be like him as a Democrat from New Orleans. Somebody pulled me aside and said, you think that's the best guy to point to if you're running for state rep in St. Tammany and Covington? I mean, they were right, you know, like that's not exactly the kind of thing that my voters say, yeah, that's the kind of rep I want, right? But he was pointing to the core of the problem. It's been the core of the problem for us for years. Edwin Edwards, addressing the convention, the end of the convention, basically said, I was all in favor until you started legislating, and then proceeded for years to try to have another convention. He was the one who campaigned on having a convention, went through all that, pointed out the problem towards the end. I mean, let's face it, that was one of the smartest politicians we've seen in this state, whether you like what he wanted or not. He saw some things. Ironically, we keep pointing to the 93 convention, the one that failed. He was governor then. He was officially a convict then. I mean, God bless him. I'm not taking it personal, but the bottom line is, like, remember that? He got elected with the idea it's the crook or the whatever the other guy was. I'll leave it alone. So what does that tell you? These things are not easy. They're never going to be perfect. And if there's one thing that I learned when I came in, did a few bills, and tried to get a sense of developing a convention was that there was always a reason why we couldn't do it. There's always going to be some reason why we can't get it right. We can't do it. This is our opportunity. And I dare say if we don't take advantage of it, we're not going to see that opportunity. One of the big opportunities is we have a governor who is willing to step out and make this happen. And why that's important? Because just like with the 200 and something constitutional amendments we've had, it's like running a statewide election. You try to pass a little amendment. My favorite is the amendment that we put on the ballot to allow 2 people from the LSU Board of Supervisors to be from out of state. My people thought it was a conspiracy. You probably thought the same thing. I mean, there was stuff online that was ridiculous. That is not the kind of thing that we should put on a ballot and have a statewide election. Don't get me wrong. Our people are smart. I'm sure they can figure it out with time, but that's the problem. We're elected, we're hired to come do the job. I know every single one of you can think of at least one issue where you go home, you talk about it, and people don't understand. They think there's something else behind it. They think it's a special interest. They think it's a conspiracy. We've drafted the Constitution. Whatever the case, you name it. But you know in your hearts, when you've been in committee and you've talked to colleagues for however long, there's a whole lot more to it. And if you're honest, when you're talking to the constituent or another constituent, you realize that's what representation is. That's what representative democracy is. We're here to do a job, to figure it out, and eventually lead and make hard decisions. And for 50 years, we haven't made hard decisions because we keep tightening the rope. There's nothing left for us to do except next spring, cut hospitals and education, and that's exactly why they're supporting us doing this. They realize we have to make some hard decisions. I'm going to tell y'all, I was here, besides the fact that I was a special election and we're talking about conventions and stuff like that back then, I sat in that desk for 2 special sessions about the .45. Some of y'all were here, I'm sure some of y'all watched, and you know, I'm telling you, that was amazing. I was amazed. You think, we're getting some emails from people around the state about whether to have a convention. That was nothing compared to the stuff we got. Granny, LSU football, you name it. We did not have a governor who was supporting a convention back then, was not supporting a solution. Folks, there's been so many things thrown about today. I know people took issue with me saying protect this or that. But at the end of the day, that is part of the problem. That's the root of the problem, if you ask me. And here's what I mean by that. There's a real study shows that every for every 1% decrease in trust in the public, it increases a constitution by 75 words. That means the more words and the more things you do and pile on and make them legal or put it out there that you can't reach, that just shows they don't trust us. They don't trust the people who have been here, God knows since when. Maybe Governor Long or whatever the case may be. There's only one way out of that, okay? I realize a lot of people don't trust us, don't trust me. I get it. We need a lead. We need to make some decisions and look at the hard things and keep moving, okay? We're not going to agree to these things. I sure hope we move forward with it. I would encourage you to support it and get us out of autopilot. And look, at the end of the day, we can make a decision to go forward. We can do this no matter what people say, no matter the emails we get about pensions or you, okay? I get it. Some people are afraid of things. But that's what we're here to do. There's a reason why it's only 2 weeks. You can't rewrite a constitution in 2 weeks. I don't care what kind of news articles or people out there or ads and things like that. You go look online, you'll see stuff in Google. There's new websites about what we're going to do or not do. We're not going to take away money. We're not going to take away pensions. God bless the people who are trying to solve that. I'm not criticizing you for that. Nobody in here is talking about taking away money from people who are retired. I hate to say it, but the way we do pensions isn't any good anyway. We could have done it a lot better years ago. That's just me talking. Folks, I just encourage you. I really hope you've decided to go forward with it. We can reorganize this Constitution in 2 weeks, and the truth is we'll have a lot more time than people are letting on to be because we don't need 2 weeks. We'll have years to work on it, and that's the whole point of doing a 2-week reorganization. You can only do so much. I look forward to being a part of it. We were elected to do these kind of things. I don't know that we need to have a road show or anything like that. People are going to see this document August 15th. That's almost as much time as they have for any other election in this state. They'll be able to vote on it in November. If they don't like it, they'll be able to kick us out. Thank you, members.
Representative Wright, will you take a question? He waves. Representative Phelps for the floor.
Thank you, Ms. Acting Speaker. The term that Representative Wright couldn't remember about the crook, it was the crook and the racist. So I come before you today with the new game that I was talking to Representative Wright about when he came up front. I'm sure some of you saw that. I don't really take this as a game when we come here to represent the people who are out across this state. Thank you, Representative Fontenot, for making the reference that that's what we're here to do. It's really not about the vote and the question and the answer that I gave to Representative Wright. Again, and I said, when did that start to be the precedence here of putting on an amendment for the people who ask us to do that? Well, his answer to me today was the rules changed. The rules that is the rule for today. I didn't come here for that. I didn't even prepare for that. What I came here to do was represent the people that sent me and to see how this process was going to go. We all know there's a majority in this building. It's been that way for the last 8 years. So that's nothing new. But the disrespect, and because you don't agree with someone, I think that has gone a little bit too far. What I was saying to Representative Wright, the tone in his voice and the look on his face was very disturbing. Thank you, Representative Boyer, for actually asking us to stop. But I think I had a right to say to him, why was that a rule for today? When we talk about what's going on here, we all know that we will not agree. Thank you, Representative Landry, for saying we know what's going on in this building. But how dare you not even hear what other people have to say because they don't agree with you, the millions of these people across our state. It's okay to disagree. But I don't think I've disrespected anyone in this building about the way that they feel about a bill or a process. I have not, Representative Wright. That's why today, and we always, Representative Cruz, we always talk about praying here. This is something that's been on my mind for a very long time. I think we better be very cautious of how we use prayer and religion in this building. We all know why we do certain things, but there's one person, if we believe in God above, he knows your heart and why you're doing things. And we can go have the majority, do whatever we want to do, tear up the state, help the state, whatever we think it is, and not be inclusive. But I guarantee you one thing. The God that I serve, there's a saying that says the devil may mean it for bad, but there's only one judge here, and he has the last say-so. So we should not be surprised of how things turn out. It may be the way one person wants it, one other side wants it. But I'm going to ask us as we move forward in this term, if Lord allows us to finish it, let's be very mindful how we treat people in this space and how we disrespect the voices outside of this building. Because one day we will be held accountable. One day we will be judged by the ultimate judge. And I don't come here to play with God either. So I'm very cautious about what prayer groups I'm in. So I wanted to say, spiritually, this day was bothering me. And I didn't expect the game plan, Representative Wright. I just didn't do it. And I'm going to ask that we not do that again. This situation is too serious for this state. And I thank you for your time, Mr. Acting Speaker.
Mr. Speaker, for the floor.
Thank you, Ms. Acting Speaker. I didn't think I'd be coming down here this term. And I want to speak on something real quick that Rep. Jordan had asked multiple times on the bill that we're fixing to vote on and the ability to be able to work within the inside of that bill in a convention. And there's 3 points I want to make. There was a Supreme Court decision regarding the 1913 convention. It was used as a basis of an AG opinion. It said, once the legislation is passed, to call a convention, that piece of legislation covers the items to debate. The AG's opinion in 1992 said that the convention will operate within the bounds of the bill that was passed. And Joint Rule 44 from 1992 said that the presiding officers would rule on germaneness. So I certainly hope that those 3 points give some of you some comfort. So right now, what I want to do, I ask God to guide me first. So I want to build a record. And I might be here a little selfish, to be honestly. Came here today, and my card to get into the Ballards didn't work. So it's just the Ballards, they let me in. Came to the Capitol. Went to go into another floor, and I couldn't get through the door. And if you remember, in January, I stood right here, and every single one of you had your children, your grandchildren, your nieces and nephews, your loved ones around you. And I remember the speaker at the time Clay Scheck-Snyder walked into his office, and he was frustrated. And I said, what's going on? He said, they've already locked me out of the Capitol. The ballots don't work. I can't get in. And he was very frustrated with that. But it was an immediate reminder of how quick our time here is in this body. And like Cindy always tells me, when you're out, you're out. In 2016, we had a deficit. And we can argue on what the deficit amount was. But there was only 22 members that are in this house today that were here in 2016. And we were given two options: raise taxes or cut spending. And I can remember sitting right there where Turnus sitting, and a senator now, a House member at the time, brought an amendment to cut TOPS by $75 million. I didn't support that amendment, but it was to try to save the cuts in health care. And Rep. Davis and Rep. Hilferty, I know we sat, and Rep. Horton, we sat through what felt like years and years of testimony in Ways and Means. And so many people came just begging us, please don't cut us. I can remember driving to the Capitol multiple times after just being elected with tears in my eyes thinking, is this really what it's about? So again, I want to build a record. I heard the question asked, what happens when we go back home and someone asks why we voted for this bill? Why did I support this bill? Why am I going along with the process? It's amazing to me the amount of fear that people have for no reason. I mean, I heard that if such and such member votes for this bill, we're going to have a recall. Does that make any sense at all? I've heard what gets looked at in this constitutional convention. I've heard, what will the governor do? I mean, I saw the man stand right here and ask us to vote for another minority district in Congress and the Supreme Court. I've seen him basically have a revolving door on any person that wants to go and sit with him and share your concerns and try to address those. Every single member that's asked for a meeting through me, I can assure you, I've gotten one. Time. We need more time. So you might be asking, why did I say I'm being selfish? I think if you look at the first two slides right here, it's obvious that we're losing. What are we losing? We're losing our people. When you look at the first, I don't know if any of you stopped and looked at this, but the first two categories on the first slide shows 50,000 plus children have left public and private school education. 50,000. When you look from 2016, which I'll remind you was a deficit, going into 17, which I will remind you is a deficit, going all the way to where we are in 2023, what are we losing? Population. So what I'm fearful of is when I was getting dressed this morning, putting on my tie, I had a picture. I had three pictures. Savannah, she's 21. She's at LSU. She wants to go to med school. She works 12 hours a day studying and preparing to get into med school. I watched Jillian, who's 17 years old, who's fixing to be a senior in high school, and is going to be thinking real soon about where she wants to go to college. And I look around at all of my friends, and let me tell you, I love each and every one of you. And I know how much it hurts when your child leaves the state to get educated somewhere else. I look at Cooper. I could say so many things about Cooper. But this year he was asked to play on the high school tennis team in 7th grade. And I missed every match to be here to make a change. So we don't have time. Our people are leaving the state. And I'm going to go back home and I'm going to tell them I did everything that I could to make sure that my children have an opportunity here. Because I know you want the same thing that I want. Last night I was sitting down with Governor Landry and his bride, and he said, "Fear is a liar." I said, "It's one of my favorite songs." I wasn't going to come down here today, but I'm doing it for my children. And we can talk about politics all we want, but to me, I just want them to have an opportunity to live, to work, and to retire in our wonderful state. With that being said, I support this bill. Thank you.
Mr. Speaker, do you want to take questions? Okay, he waves. Representative Boyer to close on your bill.
Very proud to call that man our speaker. I don't think there's anything else that I can add that would do it justice to what our speaker just said. And I simply ask you to consider it in your heart and make some bold decisions for the Louisiana, for our future, and I ask for move final passage. Thank you.
Rep. Willard, why do you rise?
I'd like to request a lockout.
Will 20 members join Rep. Willard in a lockout? Quorum call, I'm sorry. The clerk will close the machine. Lockout. 21 members call for a lockout. Lockout is obvious. Quorum call. Members, please vote your machines. Members, vote your machines. Members either voting. The clerk will close the machine. We have 102 members present and a quorum. Representative Boyer moves final passage of the bill. Those in favor vote yea. Those opposed vote nay. Madam Clerk, please open the machine. Members, vote your machines. Members, vote your machines. Boyer, yea. McMakin. Members either voting. The clerk will close the machine. We have 75 yeas, 27 nays, and the bill finally passes. Rep. Boyer moves to adopt the title. Moves to reconsider the votes. Bill finally passed. Lay the motion on the table without objection. So ordered. Rep. Boyer for a personal privilege.
Members, obviously this process isn't over as it moves to the Senate, but at this juncture, I just want to say thank you to our staff, Trish, Annie, Sarah, thank y'all, and Caroline.
Madam Clerk, open the machine for co-authors. Members, vote your machine for co-authors. Members, vote your machine for co-authors. The clerk will close the machine. We have 51 co-authors.